See Lieutenant Matthews, checkpoint.
Well, thank you very much. Hey, I'm just happy to meet you. Good to be seen. Thank you.
That's the judge's line there.
Good morning. I know.
Those are my favorite as well, sir. Something like that. Yeah, but they're not at all. Yeah.
All rise. The Superior Court of Fulton County, Atlanta Judicial Circuit is now in session. The Honorable Euro Glanville, Chief Judge presiding. Court will now come to order.
Good morning, ladies and gentlemen. Please be seated.
Okay, ladies and gentlemen, let me go ahead and first, again, good morning to everybody. Let's take roll and account for everybody. Mr. Adams, Khalif Adams.
Good morning, Judge. Chairman Collins on behalf of the community.
Good morning, Matt. Okay, good morning. All right, Durante Beebe.
Good morning, Your Honor. Durante Partners. Mr. Beebe's present.
All right, good morning, sir. All right, Damone Blaylock.
Good morning, Your Honor. Justin Hill here on behalf.
Good morning, sir. All right, Jeffrey Williams. Good morning, Mr. Williams. Good morning, Mr. Adams.
Good morning, Judge.
All right. Cordarius Dorsey.
Good morning, Your Honor. Salute Child against the government.
Good morning, sir. All right, Christian Eppinger.
Good morning, Your Honor. Eric Johnson.
Good morning, Mr. Johnson. All right. Mr. Menez and Mr. Farley, good morning, gentlemen.
Good morning, Your Honor.
All right, Javon Fleetwood. Mr. Fleetwood, good morning again, sir. Demikian Garlington. See in the corner over there? Thank you. Good morning, sir. All right, Quantavious Greer. Okay, I think we've taken care of him already, that's right. All right. Okay, Marquevius Huey. Mr. Matthews, good morning. DeMonte Kendrick. Mr. Weinstein, good morning, sir. Denise McMullen. To the corner, thank you. Appreciate it. All right, Tenquarius Minder.
Good morning, Your Honor.
Good morning, Ms. Moore. Good morning, Ms. Fagan.
On behalf of Mr. Mendes.
All right. All right. All right, Ms. Bernard, good morning. Good morning, Mr. Myrick. All right. Cormarvius Nichols. Okay, good morning. Yes, Mr. Harvey is taking care of another legal matter that's in conflict. Are you going to just cover for him, sir?
Yes, sir.
Okay, thank you very much. Mr. Nichols, you were explaining that, sir? Is that correct? Or Mr. Harvey is? All right. Okay, just want to make sure. All right, Rodeus Ryan, Ms. D. Williams.
Mr. Honor, Angela D. Williams.
Good morning again, madam. All right, and let's see what else we have. We have, all right. Mr. Sledge, is Antonio Sledge here this morning?
He is Judge Derek Wright.
Good morning, Mr. Wright. I hope you're feeling better, sir.
I am feeling 100%, Judge.
All right, wonderful, wonderful. Good to see you, sir.
Good to see you, Judge.
All right. Trontavious Stevens.
He's present.
All right, Mr. Stevens, your attorney told me of an issue she has as well. She should be here shortly, okay?
Yes, sir.
All right, thank you. All right, Shannon Stillwell, Mr. Sharp, Mr. Botts, good morning. Good morning, Mr. Stillwell. Okay, Mr. Hoover, good morning, sir.
Good morning, Your Honor.
I see him, sir. Thank you. All right. Okay, I think I've accounted for roll for everybody now. Let me just kind of go through a couple of housekeeping things. As I understand it, Ms. Rosenwasser and team from the state, that you have your other witnesses lined up. Mr. Palcic, Dr. Henninger, Mr. Bernini, and Mr. Worrell. Is that correct?
Yes, Your Honor. We'll have everybody here this morning.
Okay, and then you have Mr. Hall, who's supposed to be here
I believe the first one.
somewhere at 1 o'clock. Okay, all right. So we're still lined up. Any issues, madam?
No issue.
Okay, I just want to make sure. The other thing I would just share with everybody is that the court sometime, don't know when, I have an unrelated appointment that I may have to leave suddenly for, so if so, we'll take an hour recess and I'll take care of that and come back. I wish I could have deconflicted it with the schedule that we have, but I hope you'll indulge my patience with us in that respect. The other thing I wanted to mention in regards to start times, it's been brought to my attention that there have been there are a lot of people watching this trial, as you can imagine. So just for the explanation factor of, the court may say, well, we're going to come back at 1 o'clock, and then it might be 2:30 or 3 o'clock by the time we actually get started. There are a number of things that go on behind the scenes to make justice run seamlessly and to make sure that there's a fair trial, a just trial, and a lawful trial as to all sides. So for those of you that might be watching or listening to this trial, understand this, that there are a lot of things that go on behind the scenes that you're not privy to, in the sense that scheduling of witnesses and other things that, as much as we try as lawyers and judges to keep to a schedule, that's sometimes aspirational and just doesn't happen. As you can see, that we've had to shift and otherwise move things around for other witnesses and other people, and to take things out of turn as we see it. So hopefully by way of explanation that satisfies your curiosity in terms of what happens. But to the extent that we don't get started on time, of course, you can always blame me, because I'm the judge in charge of these proceedings, but some of those things we don't have any control over. But just by way of explanation, we're not trying to waste your time or otherwise not be professional advocates. It's just the trial of any case is not an exact science. Any trial lawyer will tell you that there are a number of reasons as to why that trials don't start or don't continue on a linear path. So I hope that by way of explanation, that has satisfied your curiosity. Okay, any other administrative announcements from anybody before we go ahead and start up? Okay, hearing none. State, call your next witness.
Your Honor, we will call Investigator Daniel Worrell.
All right, summon Mr. Worrell, please. Mr. Worrell, good morning, sir.
Good morning.
If you would be so kind to approach the witness stand, once you get there, turn and face Deputy Talton to be sworn as a witness, please.
You swear to affirm the testimony to give the court the truth, the whole truth, and nothing but the truth.
I do.
Go ahead, take a seat. Spell your name.
My name is Daniel Worrell, Daniel Worrell.
Okay. Good morning.
Good morning.
Investigator Worrell, where are you currently employed?
I'm an investigator at the Office of the District Attorney on the Blue Ridge Judicial Circuit.
And how long have you worked there?
Coming on 2 years.
And where were you working before that?
The Atlanta Police Department.
How long had you been there?
I began my employment in 2008.
Okay. And what are your duties at the, as an investigator at the Blue Ridge Circuit right now?
I am assigned cases that vary from drug possession to murder. I prepare those cases for the attorney, collect evidence, interviews, things of that nature.
And what were your duties with the Atlanta Police Department at the time that you left?
I was an investigator assigned to the Criminal Intelligence Unit.
And, oh, sorry, go ahead. No, I didn't realize I cut you off.
There, we focused on violent crime, gangs. I had a particular expertise in digital evidence, phone records, and things like that.
Now, can you explain what you mean by digital evidence?
So CDRs are call detail records, phone records, social media, things of that nature, not physical evidence.
Do you ever do any work with that at your current job?
I do.
Okay. And did you ever do that at any other law enforcement positions?
No.
However, while I have you here, I will ask you, can you go through all your past law enforcement experience?
Yes. I was, for sworn, I was employed by the Atlanta Police Department. Before the Atlanta Police Department, I worked for the Florida Department of Highway Safety and Motor Vehicles as a communications officer. That wasn't law enforcement, but it was connected to law enforcement. But then in 2008, I was hired by the Atlanta Police Department.
And do you have any relevant education, college, anything like that?
I have a bachelor's degree in criminology.
Okay. Have you attended training as a police officer, investigator, and throughout your career?
Yes.
Can you detail some of that training?
So I have close to 2,000 hours of post, which is the police officer standards training. Ranges from going through the academy, through high-risk warrant service, to digital evidence, undercover operations, the list goes on and on.
Can you specifically explain if you've had any training on cell site location information or extracting digital evidence from cell phones, et cetera?
It's more closer to cell site location information, mobile forensics. I've dabbled in, but I'm not.
Specifically as to cell site location information and digital forensics, can you explain the training you've had there?
Yes. I attended training with Hawk Analytics, I believe it was 2018, for cellular technology, mapping, and analysis of CDRs and cell site location information. I've attended training with the FBI's cellular analysis survey team for understanding investigations for modern telecommunications. I've attended training with the Secret Service at the National Computer Forensic Institute on digital evidence, where we had a module on cellular technology as well as mobile forensics. Attended training with ZX, which is a private company that creates mapping technologies and things like that. That was also pertaining to cellular technologies, mapping analysis of cell site location information and CDRs. Had another training with Hawk Analytics for tower dump analysis, which a tower dump is requesting records from network carriers for specific locations that certain towers cover.
Okay. And is that all part of the continuing education that you do to keep up with your work at the DA's office and in other offices you've worked in? Do you do any other continuing education that I haven't asked you about?
I'm currently in the middle of a modular e-learning training on forensic analysis of networks. It's through ZX as well.
And what do you do to keep up with any developments in this field and make sure that you're up to date on the trainings?
So I monitor the National Domestic Communications Assistance Center, which is provided by the FBI, which will give updates on digital evidence and things of that nature. I try to keep in contact with other experts in the field when it comes to cell site location information, so FBI agents who are attached to their cellular analysis survey team, things of that nature.
Your Honor, at this point, I would like to show the witness what's been pre-marked as I do not know what number we are on. Is it
Let's find out, Ms. Reaver.
We are on 12.
on 12?
Stage 12.
What has been pre-marked as State's Exhibit 12. And I have it here if anyone would like to see it first.
Is that the CV?
It's the CV. It's been provided in discovery.
All right, you may approach, madam.
Thank you, Your Honor. Would, sir, do you recognize this document?
I do.
How do you recognize this document?
This is my CV.
Have there been any additions, substitutions, alterations, deletions as far as you can tell?
As far as I can tell, no.
Your Honor, the state would move to admit State's Exhibit 12 to evidence for the purpose of this hearing.
Any objection? All right, having hearing none, stage 12 is admitted.
Thank you, Your Honor. And Investigator Worrell, you've detailed a little bit that you've done some of this cell site location information work in your current job and your previous job. Can you detail about how often you did this work both at the APD and now?
With APD, it became a daily thing. I was consulted a lot with or by other investigators who had phone records that they needed interpreting and analysis for. I would look at phone records every day. When I moved to the district attorney's office, it's, I would say, weekly that I look at phone records and consult with attorneys and investigators in regards to their evidence pertaining to that subject.
Have you ever given any kind of presentations, writings, anything like that that I haven't covered?
I've given a couple presentations, yes.
Can you detail those?
One was a training for our investigators at the district attorney's office, which focused on briefly on the technology, but as well as investigative techniques that you can apply using CSLI and CDRs.
And does CSLI, is that cell site location information?
Correct.
Okay. Keep going, I'm sorry.
Another was a presentation a year or two ago at a gang investigators meeting in regards to investigative techniques on applying phone records and things like that.
And so I think you said currently do any investigators or detectives come to you to ask you about how to do this?
Yes.
And are you able to explain how this cell site location information works?
Yes.
Okay. How often, and I know this is going to be a hard question, about how many cases have you done, would you guess, ballpark, cell site location information for? Ballpark is fine.
Over 100.
Okay. Have you ever testified as an expert witness in a case regarding cell site location information?
I have.
Okay. And how many times have you been qualified as an expert?
7 or 8.
And what courts were those in?
Here in Fulton County and Cherokee County.
Okay. And what specifically were you qualified as an expert in?
The analysis of call detail records with historical cell site location information, so it's kind of a mouthful, but the analysis of historical cell site location information.
And finally, do you have any awards, commendations, or anything else that we haven't mentioned?
No.
Okay. Can you explain how cell site location information is generated?
Yes. So when we enter into a contract with a network provider, let's say Verizon or AT&T, we're issued our device as well as our unique subscriber information. Now, cell site location information CDRs with cell site location information originated more as billing purposes. The providers needed to keep track of kind of what their clients, their activity was, only to really just maximize their product. They needed to know, if they were getting dropped calls, and as well as how they were going to bill their client. It used to be a time when we would be charged for going over our minutes and more texts and things like that. So that's kind of how these records were initially created. So anytime that we make a phone call, a text, utilize data, it is tracked by the network provider, has general information of date, time, who we're calling, and as well as which cell site or which tower enabled that cellular transaction, which enabled the connection to the network.
Okay. And so does this process generate information about locations when you do it correctly?
Yes. So depending on your carrier, they will provide in that particular record, you'll see the transaction, whether it's a voice or text, and then you'll see which tower was responsible for making the connection.
Okay. Now, how do you use this information when it's generated?
So at the request of law enforcement, we can see a particular number of cellular transactions through the call detail records, and we can generate maps based on that information, but also we can see the locations of the towers just through the spreadsheets that are provided with CDRs. From there, based on the relationships, based on neighboring cell sites, we can determine a general area of the device that utilize those towers.
Okay. Now, I know you mentioned a lot of trainings previously. Are there specific trainings that taught you how to do this method so that you can interpret and map out these cell locations?
Yes, the training with the FBI, training with all of the private companies, Hawk Analytics, and prior training, yes.
Are the same methods used in all these by all these agencies that train you?
Generally, yes.
So is there sort of a generalized, specific method?
There is a generalized method, yes. Yes, of evaluating the records, mapping the records, and interpreting those records, yes.
Okay. And are there certain procedures for how to evaluate the data that you obtain?
Generally.
Okay, and can you describe the procedures that you have to use?
So typically, when we receive the CDRs from the carrier, we will utilize it. I will go through and evaluate the data that's useful, and then I will utilize a mapping program to map those specific CDRs, and then go back and double check through, basically by hand mapping those records to verify that the locations were correct. And then, of course, using neighboring cell sites, you can determine a general area of a device.
Okay. And is this basically the main method that you've learned on how to extract this data?
Yes.
Okay. And has this method of mapping locations based on cell site location information, has this been tested for accuracy?
Yes. Agencies like the FBI will do drive tests to determine radio frequency relationships between cell sites and the devices. Carriers will also generate propagation maps which show radio frequency strengths and things like that. So it's generally accepted.
And if I'm understanding correctly, you can't pinpoint an exact location, but you can get a general location. Is that fair to say?
Correct.
Can you explain that a little bit?
Right. So based on CSLI, we're going to see the towers that are being utilized by the device, but we're not going to know the specific location of the device. So CDRs with CSLI will not, those GPS coordinates that you might see on them aren't the device, they're the cell site specifically. So we'll have a general area of where the device is based on the utilization of those towers, but we're not going to know, okay, that, it's at the corner of, Trinity and Pryor.
And has this method that you use, that you've learned how to do these, has this been published anywhere? Is it written down? Is it something that you learn in these trainings? Can you explain whether there's written guidelines or anything like that anywhere?
Yeah, mainly through trainings. That's where I've learned it. I believe the Scientific Working Group on Digital Evidence has also issued some recommendations, but this generally coincides with the same training that I have.
Okay. And if I understood you correctly, that's the same training taught by the FBI?
Yes,
Okay.
basically.
So that goes to my next question. Is this something that's regularly used by other police departments and federal agencies?
It is.
Can you name a few that might use it?
Atlanta Police Department, the FBI. Several agencies I've worked with when I was at APD. I don't know of an agency that isn't really aware of phone records and using them.
Fair enough. And do you know about how long cell site location information has been something that's accessible and been being used?
Well, the cellular technology started in the late 80s. I would say that was probably the beginning of that type of technology and that type of documentation. As to a specific time when law enforcement started using them, I couldn't really tell you.
So I think you said you've been working with APD, you started working with APD in 2008?
Yes.
Was this something that was being utilized the whole time you were working with APD?
When I became an investigator, which was 2015, was really when I started seeing CDRs with CSLI, and I started working cases. It's not widespread. It wasn't widespread throughout Atlanta Police, but certain detectives would utilize them and be able to interpret them, and I would consult with them as well.
So would you say that this method, do you know whether this method is generally accepted in the field of policing as a reliable investigative tool for determining an individual's whereabouts during a period of time?
General whereabouts, yes.
Okay. Were you provided with Javon Fleetwood's cell phone records
Yes.
in an incident in this case?
Yes.
And did you use the principles that we just talked about when you evaluated those cell phone records and created mapping?
Yes.
Okay. And based on that, were you able to develop a report that included location information?
Yes.
Okay. Your Honor, at this point, we would move to qualify Investigator Worrell as an expert in cell site location information and data based on his experience, the many trainings that he's attended and taught, and his general knowledge of CSLI and how it works.
All right. Any cross? anybody?
I literally do that just a couple times.
Oh, sure. And you want to start the day off that way? Okay, all right.
Now, you're able to get cell site location information from the phone subscriber company?
Yes.
Okay, so you don't need defendant's actual phone to get that location information?
No, all you need is a phone number.
Okay, thank you. Those are my questions.
Excellent. Okay. Mr. Adams?
I've got a few.
Okay, all right.
And then just to be clear, you're seeking to qualify him as an expert in the field of historical cell site analysis, is that correct?
And cell site location information, CSLI.
Okay. Another point of clarity, I noticed that he said earlier in his testimony something about social media. You are not seeking to qualify him as an expert in social media analysis or interpretation?
Nope.
Okay.
Cell site location information, historical cell site data.
All right, thank you. Investigator Worrell, good morning, sir.
Morning.
A couple questions for you. If I heard you correctly, I think you said that you get this cell site data information from the subscribing company. Is that correct?
Right. Verizon, AT&T, the major network carriers.
Okay. Once you get that information, I think I heard you say that there's a map that is generated of a particular cell phone location based on the cell towers and the cell site locations and so forth. Did I get that right?
Maps of the cell sites that were utilized.
Okay.
Yes.
All right. And so that's my question then. In terms of, do you know what the methodology is that allows for the creation of or the generation of these maps? Is it a computer program or?
Yes. So I could map by hand a CDR. If I took, let's just say, even 2 days worth of data, it would probably take just as many days to map out those records,
Okay.
just based on how many there typically are in a CDR.
Okay.
So a mapping program is there to assist in mapping, as well as kind of a presentation of which cell sites are being used.
So it is something, the generation of a map, because that's where we begin. The generation of a map is something that can be done either by hand, a human, yourself, right? Or it could be done with the assistance of a computer program that assists in generating these maps.
Correct.
Right. So that was my question specifically. If we're talking about a map that is generated by virtue of a computer program, are you familiar with the workings of that computer program, the methodology that computer program uses?
Well, I mean, I'm not a coder, so what it does behind the machine, no. But when it comes to the mapping, I'm always of the opinion that I should be able to do the exact same thing that machine should do. So I understand what it's pulling from the CDR to map the information.
All right. And so whether you are creating or generating that map simply by virtue of the computer, the computer program, or whether you're doing it with the assistance of the computer, or whether you're doing it yourself, are there noted standards and policies and procedures for how you do that? In other words, are there instructions that this is what you look at, then this is what you do, and then this is how you apply the information? Are there standards, written standards that you reference in doing that?
Well, written standards, each carrier presents their information differently. So there may be a carrier that gives a latitude and longitude of the cell site that's used. So there may be a carrier, Sprint is a good example of a carrier that uses a code showing which cell site is being used. So then we have to actually access a different record from that carrier to decode which cell site is being used. So yes, there are recommendations on how to interpret each carrier's records.
Okay. And so when you're saying, you're using the word recommendations, which I think, correct me if I'm wrong, right? When you're saying recommendations, you're talking essentially about instructions.
Yes.
Okay. Now, those instructions that would govern the process for evaluating and mapping location, are those recommendations or instructions that are peer reviewed? In other words, are there different agencies that reviews those instructions and says, this is accurate, this is the way that it's supposed to be done, and this is an accurate way of doing it?
Well, it's funny because the carriers also will give instructions on what the meanings are of their records. So in a way, we use the carrier's recommendations and the carrier's instructions to interpret them, not really interpret, but to discern the information that they provide.
Who reviews the carrier's information?
I mean, whoever requests information from the carrier.
Okay. And who reviews the accuracy of the information provided by the carrier?
Whoever requests the information from the carrier.
Okay. That would be you, for example.
Right.
All right. So in terms of, you got the carrier, the information is then generated and sent to you, right? And you review that information that's been sent to you by the carrier.
Right.
Right. So my question is this. Let's jump above the carrier. Before that information is sent to you, is there an agency, an entity that reviews the accuracy of the information generated and sent to you by that carrier?
I'm going to have to go through this line of questioning. We're disqualifying him in analyzing the call records, not in the accuracy of the records themselves. I think if you'd like to challenge.
Yeah, they more so go to cross for trial, Mr. Adams. I would concur. I'll sustain the objection.
If I may just respond briefly, Judge, I would suggest to the court that in terms of the accuracy of information that is provided that then later becomes part and parcel of any reports that are generated, I think the testing or the accuracy of that information is relevant and would go to as the overall analysis of whether or not it's been sufficiently peer reviewed such that it meets the standards for admissibility of his testimony as an expert.
Your Honor, I think what we're just doing here is qualifying the science of CSLI and whether he is qualified to testify about that. I think this is something that would go more to waste.
Yeah, I would concur. I'm going to still sustain the objection.
All right, yes, sir.
Okay.
I'll move.
All right, go ahead.
All right. You testified a little earlier, Investigator Worrell, about the next step in the process, right, is there being a general location versus a specific location that's determined in the analysis of the data, right? Okay. Now, I don't want to get into the weeds because we're not here to kind of cross-examine the intricacies of it, but you know, for example, that the science tells you that a location can be determined, or a cell tower can give you a location based on the signal coming to it from the device, right?
Right, the communication between the tower and the device.
Right. You also know, of course, that sometimes a signal from a device can bounce off of one tower to another tower when the device is being used. You know that.
Like a handoff?
Yeah.
Yeah.
Yes. Okay. Now, so that brings me then to my question about how you're able to determine the general accuracy of a location. Right? When you look at the cell site data, you generate a map, and you see either a general location, as you described it, right? You see a general location, whether you're able to determine the accuracy. Is there a mechanism for determining the accuracy of that? In other words, can you determine whether or not it actually bounced off of one tower or another tower? Is there a way to test that?
So, in the CDRs themselves, again, depending on the carrier, they will show whether multiple towers were used. AT&T, for example, will show every cell site that one call may have used. So, yes, you can see handoffs there. T-Mobile may show a first and a last cell site, so how the call was originated and how the call was terminated. Typically, they're the same. Sprint, the same. First cell, last cell. So you can see handoffs better with AT&T, but then you will see, like I said, first and last cells with other carriers.
All right. Do you know, if I use the term error rate, you know what I'm talking about? Mm-hmm. All right. Do you know, for example, if there is a way to test what the error rate is of any information that might be provided by the provider that details a location or a tower? Or
specific error rates, I would say, depend on the carrier. I would say, Sprint, for example, to me was a little bit, had a higher error rate. percentage-wise, I couldn't tell you, but it's all in kind of the evaluation of those records too. You want to see abnormalities when it comes to cell site information. So if I see that there was several towers in downtown Atlanta, and then 30 seconds later there's a cell site that's used miles away that is physically impossible, that to me shows an error rate with the records. And it can be explained, but as to, I can't give you a percentage of what the error rate would be, but yes.
Would it be fair to say then, and obviously you don't work for the companies, but would it be fair to say that you cannot give us a specific error rate for Sprint versus AT&T versus, I don't know, Verizon might have been enveloped by somebody else? Would that be fair to say that you can't give us a specific error rate for the individual carriers?
A percentage-wise, no, I don't. It's all in how, again, you interpret the records, as well as there are things to account for too when it comes to like attenuation of frequency as well. So mirroring and shadowing and objects, the environment exist that affect radio frequency and affect the signal between the device and the tower. So,
which would make it difficult to determine, in this case, a particular error rate of any records that would be provided by the carrier.
Correct.
Okay. Just a few more questions for you. I think I heard you say that this technology and methodology, that's what I'm going to keep using, is used by other agencies, right?
Correct.
You reference APD, FBI, and some others. Are you aware of whether those particular agencies have any procedures in place for the testing of the accuracy of the information they receive from the carriers?
Well, when it comes to testing the accuracy of the information from the carriers, are you trying to say whether the information was correct when the carriers gave it to the agencies,
That's
or
correct, sir. That's
their
what I'm
interpretation?
That's what I'm asking.
When it comes to whether, this voice call was accurate in its time or date, I don't know. But when it comes to the interpretation of the cell site information, so determining a general area, they can perform drive tests and determine what the strength of a particular tower may be.
Okay. Do you know, though, whether or not agencies that you've referenced, for example, APD, FBI, the others that you're familiar with that have quote, used this technology, whether they do in fact have procedures in place for the testing of the accuracy of the information received?
I think that's an answer. I think he just
Yes, that's an answer. I'll stand the objection.
All right. I didn't get the answer. I guess the answer is they have it in place, but you don't know how often they use it or anything.
Correct.
All right. You were asked in regards to the records that you took a look at. We're talking about in a case involving a gentleman by the name of Javon Fleetwood.
Correct.
Do you know what agency, what carrier was involved in that particular case analysis?
I do not recall if it was T-Mobile or Sprint.
All right.
There were several records that we obtained from that case. One was definitely T-Mobile, but again, Mr. Fleetwood's, I don't recall.
All right.
If I can refer to my report, I could tell you, but
Do you have your report anywhere in front of you?
I do not.
All right. That's right. That's all I've got. Thank you.
Okay. Anybody else? Mr. Jimenez, go ahead, sir.
Good morning, Your Honor. Good morning, State.
Good morning, sir.
Sudi Chalaki-Menace on behalf of Mr. Dorsey. How are you, sir? Good morning.
Good. How are you?
Good. All right. I want to just have a few questions. Now, you say you received these data from the cell phone carriers. Is that right?
Correct.
And this data was created. This is kind of like, it's a data dump. It's just metadata they give you. They give you everything. Is that correct?
I wouldn't say everything, but, the date and time of the call, who the call party was, how long the call lasted, again, the cell site, the sector of the cell site. So, yes.
And when you say cell site, the reality is that there are millions of cell towers throughout the United States. Is that right?
There are quite a few.
And the phone company doesn't own any particular cell tower. Is that right?
Own? I mean, they may contract out for property, but maybe I'm not understanding.
Let me rephrase. One cell tower could actually share and be used by multiple
Absolutely.
And then, so whoever controls that data then gives it to the cell tower, again, then gives it to the phone companies, is that right?
Well, no, the phone companies they have a retention in place where they also service the antennas that are attached to these cell sites. So, I mean, this is just records. I don't know the intricacies when it comes to who gives who the records inside that company. I don't know how to answer that.
But you said during direct that whatever records they do have, they collect them for their own use.
Right.
For example, they collect it for billings purposes.
Right.
Also, that line of questioning, I don't think he can testify why phone companies collect records. He's not a phone company expert.
I think he just answered it. He does know. If he knows, he can answer it. If he doesn't know, he can say, I don't know.
Okay, well, can you answer that, Mr. Worrell?
The records initially, when I would say there are many factors when it comes to why the records were kept by the carriers, one of which was originally billing when like I said, when we would have a limit on minutes or texts or things like that. But as well as they use these to know if their product is also working. So they determine whether there's a dropped call and kind of just the status. This is just in-house records that they keep. This wasn't developed to track or do anything like that.
So that's key. It was not developed to track their clients. Is that right?
I don't know when it comes to their intentions. I would say that because of the nature of the records themselves, it shows location information. I don't know the conversation that a carrier would have in regards to like why we're keeping these records. But I would say when it pertains to law enforcement, they don't retain these records so that they can just give them to law enforcement for law enforcement to track. What they do with their records is their business, but we know that they exist, and so we request them when it's necessary.
So let me pivot a little bit from what you just said right now. Law enforcement gets these records for them because you know they exist. Is that right?
Correct.
And to get them, you actually have to either subpoena or get a warrant.
With cell site location information and search warrant, yes.
Okay. So they don't just freely give it to you. There's actually a process.
Correct.
Now, you've received quite a bit of training. Is that right?
Yes.
You listed a number of years, thousands of hours that you received in training, specifically as to cell tower locations.
I would say my total number of training is close to 2,000. I wouldn't say that's all dedicated towards this type of technology.
And is it fair to say that all the training related to this type of technology has been given to you by either a law enforcement agency, the FBI, or some other company that is in the process of helping law enforcement? Is that right?
A company, they'll help law enforcement, they'll help, I think, anyone that requests their help. I don't know who their clients are, but could be.
But have you ever gotten training by Verizon?
No.
Have you ever gotten training by Sprint?
No.
Have you ever gotten training by T-Mobile?
No.
So the actual phone companies, the ones that have these records, have never trained you in how to use it?
Correct.
All right. All the programs that you mentioned, these are third-party private companies, is that right?
Correct.
They are not the phone providers.
Correct.
And what they do is they take this metadata and then they make it pretty into a map. Is that right?
They will, yes, map the data.
So it makes your job easier. You know how to do that.
Correct.
You can look at one location, you can look at a second and a third, and then you triangulate where that actual phone may be.
No, I don't do it in regards to you seeing multiple cell sites that were used by the device. I don't triangulate. I show the cell sites, and then you will see, I will map the neighboring cell sites for that carrier. When, I don't triangulate.
Okay. So how do
That's getting more specific. That's actually trying to show a specific location.
Do you know how to do that?
No.
Okay.
That's not what's done with CDRs.
Okay. Now, you are aware that there are apps, there are softwares that can emulate another phone number. Is that right?
Correct.
and then you're only going for the phone number. You're not actually looking for the device. Is that right?
For CDRs with CSOI is the phone number. Yes.
So if somebody's emulating,
I'm going to object to this line of questioning. We're just asking if the science itself is reliable.
Yeah, I mean, this is all cross-examination, Mr. Jimenez.
yes, Your Honor, and if I may respond, when
It goes to weight. It doesn't go to the criteria of admissibility of the science itself. That's the only thing that, this is a threshold under Daubert I got to decide, so.
absolutely, Your Honor, it definitely goes to weight, and we will challenge that at trial. However, this is the gatekeeping phase to make sure we're not getting any junk science in here. I mean, it is, just because law enforcement has used it for thousands of times, doesn't mean that it is good science. As counsel for Mr. Williams was asking, there is error rates. There are issues with this data. And it is not data that they're creating. It is not even data that is peer-reviewed. It's just billing information, which I would argue to the court, it was never created to track their customers. And they are just looking at numbers, looking at metadata, and getting whatever they want out of it.
Okay, anything else, sir?
Nothing.
Okay. All right, thank you, sir.
Thank you.
Okay, all right, anybody else?
Yes.
All right, Mr., you got to identify yourself for the record.
Yes, Your Honor. Attorney Eric Johnson for Mr. Eppinger.
Thank you, sir.
Thank you. Good morning, sir.
Morning.
Based on the testimony that you gave earlier, you said that you received information, data regarding the location of the cell phone, correct?
Location of the cell site.
Okay, location of the cell site. And as it relates to the actual phone itself, you said that you can't pinpoint the exact location, but a general location, correct?
Correct.
And what is the range of that location as far as how wide a net is that?
It just depends on the area. It depends on the neighboring cell sites. Each cell site may it could be within a mile, depending on the area. I couldn't tell you that one particular cell site has a range of 1.2 miles. I don't know.
Based on your experience and all the testing that you have done, what would you say is the average range that you've seen throughout your career as far as the difference between actual location and estimated location?
So, again, it's difficult to say because in an urban area, you're going to have a much more concentrated field of cell sites. In a rural area, it's much more sparse. So I couldn't give you an average range.
Okay. But you will say that it's much more difficult to obtain an exact location in the urban area than it would be in a rural area.
No, I wouldn't say an exact. It's difficult to determine an exact location. We don't determine exact locations, but I would say that it's actually more condensed range in an urban area because of the concentration of cell sites. I could show you a map, and you could visually see the thousands of cell sites within the city of Atlanta, and then as we grow further away from the urban area, you will see a less dense population of cell sites. And there's reason because of the volume of clients. I mean, here you're going to have much more use of the cell sites, and they need to maintain the coverage, and they need to maintain keeping their clients.
Okay. And I believe you testified that in this particular matter, you analyzed the phone for Mr. Fleetwood, correct?
Correct.
And that information was given to you by the state as to who the owner of who the phone was attributed to, correct?
No.
Okay, what did you get?
So I determined who used that phone through my investigation.
Okay. And so based on the information that you received from the cell phone carrier, it gives you the specific individual who made each and every call?
No, I mean, it gives us subscriber information, but attributing the number is more than just looking at the records, more than just what the carrier provides as well.
Okay. So how did you, what steps did you take to say that this was Mr. Fleetwood's phone?
Well, during the incident, there was a cell phone that was abandoned near one of the vehicles that was used in the shooting. That phone had multiple numbers attached to it, as well as conversations. I don't remember the specifics off the top of my head, but conversations that led me to believe that one user of a particular phone number was involved in the incident. That number I searched through Securus, our jail call information, and identified individuals based on that.
However, but nothing could tell you exactly who made the text messages that were given.
Your Honor, I'm not against this, the same objection.
I sustain the objection. That's trial-related cross-examination. Perfectly fine at that point in time, Mr. Johnson.
I'll move on, Your Honor.
Okay, all right.
So outside of actual location, as far as the general location that is given, what other specific or specialized information do you provide in your analysis as a cell phone locator?
Not quite understanding the question.
What I'm saying is you are here today to be attempting to be qualified as a cell phone location expert. So
No, cell detail records, cell site recognition information.
cell site recognition program. So, and I guess I don't really understand what that means. What exactly does a cell site recognition expert mean?
Your Honor, we're trying to qualify an expert in historical cell location data and cell site location information.
Okay.
Cell site information what?
This is cell site location information, it's called CSLI, is that?
CSLI, okay, and then what else was the other one?
Historical cell.
So it's, yeah,
Hold on, sir, hold on. Historical what?
Cell data analysis.
historical call detail records with cell site location information.
Okay.
Analysis.
So, does the information that you receive as far as the cell phone locations tell you exactly what person is in possession of the phone at the time?
No.
And as far as the locations that are given, these are things that come up. I believe you mentioned you can pull it up on Google Maps and see these locations.
Once the information is digested and a map of some sort is presented, yeah, you could use Google Earth, but...
Okay. So if given this information, anybody could map these things out, correct?
With a program, yes.
Well, aren't the subscribers themselves afforded? Can't they request the cell phone data information on their account from the subscribers?
No. I mean, they can request their phone records, but it won't come with cell site information.
So this information...
I mean, I've tried to do it, and I could not do it.
So this information is something that is only provided to law enforcement?
I believe, I don't know if maybe as a private citizen I could go through the hoops of trying to get that. I don't know. I couldn't answer that.
And the program that you use to analyze this data, where did you get that program from?
So I've used several different programs. Hawk Analytics provided one program called CellHawk. I've used a program that the FBI has provided, so I've used a couple.
So are these programs available to the general public, or is it just something for law enforcement?
I don't know who they're available to.
In your experience, have you ever known anyone in the general public to use these programs?
I don't know.
So it's safe to say that all of your knowledge and involvement with these programs come from your involvement with law enforcement?
Yes.
No further questions, Your Honor.
All right. All right, having no other cross-examination. Madam, anything else?
Your Honor, if the court would like to have case law, I have that available.
I'm good. I'm good. Based upon the testimony of Mr. Worrell, I'm going to designate him an expert as a CSLI and historical cell data and cell site information data expert.
Your Honor, let me pose an objection if I can. For the record, I understand the court's ruling, but I need to put on the record my objection to him being qualified in the manner as stated. I'll be succinct, and there are 4 specific objections that I have to indicate that he does not meet, this particular individual does not meet the Dalbert and 702 standards.
How? Specifically.
I'm about to get to.
Okay, let's do it.
All right. Succinctly, 4 things. Number 1, he has testified in regards to information that's provided by cell phone carriers, but he has not testified that there are any publications in support of the methodology that is used for the gathering of that information, nor has he testified in regards to any publications that are in support of the methodology used for evaluating the accuracy of that information.
Not required.
I disagree, but that's my first objection.
Okay.
Number 2, he has testified that generally he believes that these methods are generally accepted. I believe his testimony was in the field of policing. There's not been any testimony, and used by other agencies. There's not been any testimony that any of these agencies that have been used, either APD, FBI, or the one cited, has any processes or procedures in place for the testing of the accuracy of that information. I believe that he has tested.
Drive-by. Engineers can drive their information. So that's a way of testing it. What else?
Yes. He testified that he is not familiar with what the error rate is for the information that is provided. I believe his testimony was that different companies have different error rates, but he is unaware of what the error rate for the information gathered and transmitted is. And finally, there's been no testimony that there's any peer review of either the analysis done by this particular individual or any peer review of the information that is provided by any of the carriers. I believe for those 4 reasons that it fails to meet the standards set in Daubert and in 702, and I would ask that he not be qualified as an expert in the field proffered.
Okay, Ms. Rosenwasser, you want to respond to that, please? And then I'll let Mr. Johnson then go ahead. Mr. Johnson, go ahead, and then I'll let Ms. Rosenwasser respond to everything. So, anything else? Remember, everybody gets the same thing, okay? So do you have anything else you want to tell me?
I know.
Mr. Harvey took care of that for you.
I got you, Your Honor.
Okay, so is there any other base other than those 4 that have been mentioned already?
Yes, Your Honor.
Okay, all right, let's just don't replicate the 4 that Mr. Adams has eloquently presented for us already.
Your Honor, and we believe in this particular matter, Eric Johnson on behalf of Mr. Eppinger, that this individual lacks the specific, that the information that he will be testifying to is not specific, technical, or specialized in such a way that it would assist the trier of fact in this matter. He has testified that he will be giving information regarding cell phone location information.
Okay.
We believe that would be improper in this particular matter, Your Honor, because effectively, the cell phones are not on trial in this case.
But location of individuals who may possess identifying data associated with that phone, I mean, it's only as good as, I mean, the jury can decide not to, of course, consider it as evidence. They can consider the weight thereof. But, there are various reasons that cell phone data is offered for a trier of facts consideration. Yeah.
Well, Your Honor, what I would say is, ask him specifically, does the information that he received tell you who is in possession of the cell phone?
No, but what it does do is, if you associate that phone with certain information, the jury can make an assumption, if they choose to do so, remember, they don't have to,
I understand, Your Honor.
that particular individual may have been in this particular area, or that particular individual's phone may have been within this particular area. So that's helpful to try our fact.
I think that's a separate issue, Your Honor, because he's not testifying to the content of any
He's testifying to the science of whether or not the record, not the record, I should say, because the record is given from the phone company.
Right.
They get it by warrant or other permission.
Understood.
And then they go ahead and they extrapolate and present this data in terms of for the reasons they say it's offered for whatever the jury views it as.
Well, Your Honor,
that.
in this particular matter, if we look at it specifically as to what he was qualified for as it relates to location, in this particular matter, we're not speaking about what else the content on the telephones may be. As it relates to this particular location in this case, he has testified that he does not get a specific location, only a general location. He cannot even give the estimation as far as what the what the amount of error is in that estimation. So therefore, he cannot tell you specifically where the phone was, nor can he tell you specifically who was in possession of the phone. So effectively, Your Honor, they're using his status as an expert to bolster the testimony that he knows himself is speculative in nature.
All right, okay. Anything else?
No, Your Honor.
All right, Ms. Rosenwasser, anybody else? Ms. Rosenwasser, go ahead and respond to those four and Mr. Johnson's issues with the, that he's just raised.
Your Honor, it's our contention that this is an appropriate field for this individual to be qualified under Jobert. He has testified that this field is recognized. It's something that's done by the FBI, that this is done by many police departments in this state, and the fact that, Your Honor, that this is not a situation, we're not asking, he's not an expert whose phone it is. That goes to weight, not admissibility. That was my original objection to that questioning. And, Your Honor, I think that I would just, to answer all those questions, I'd like to point the court to United States versus Jackson. It's a 2017 decision out of the United States District Court of the Northern District of Georgia, which is us.
What's the site on Jackson?
That's 2017 U.S. District Court, and it's on Lexus 221421, and that's a 2017 United States District Court case. In that case, the court found that an expert, just like Investigator Worrell, was qualified to offer this because the CV in his testimony established that he has extensive education, training, and education in the fields of telecommunications and historical cell site analysis, and he has a lengthy history of testifying in court proceedings. Additionally, what is important that I'd like to point this court to is that the Northern District Court found that this is a reliable methodology, which is what the question is here. Is this a reliable methodology? The court found courts from around the country, including other judges in this district, have found that similar testimony to be based on reliable methods, and it cites to several cases that I can provide the court with right now. It cites to a case called U.S. v. Foster, Foster. That's another Northern District Court case, Lexus 89791. United States versus Lewisby, Lewisby, 843 F3D 653, 7th Circuit, 2016. United States versus Frazier out of the District Court of Nevada in 2016. U.S. District Court Lexus 126479. United States versus Johnson out of the Northern District of California. United States District Lexus Site 111921, again 2015. And United States versus Jones 918 F sub 2D1 out of the District Court of the District of Columbia in 2015. And so then the court in Jackson goes on to say, defendant's challenge lies in the assumptions that the agent might make into question the accuracy or reliability of his opinions concerning the locations of phone. But these assumptions go to the weight of the agent's testimony rather than to its admissibility, which defense counsel can go into on cross-examination. Additionally, should the court like to hear cases from other circuits, I have those. I think it's important in Rule 702. The Georgia legislature said that it's the intent of the legislature to draw from the opinions of the United States Supreme Court and other cases in federal court. It doesn't limit us just to the 11th Circuit. So I will point the court to United States versus Lewisby, which is the 7th Circuit case that was cited in Jackson. That case said using call records and cell towers to determine the general location of a phone at specific times is a well-accepted, reliable methodology. The court also found that the expert in that case was qualified with 350 hours of training in the systems used to do this. And we heard here that Investigator Worrell actually has a lot more training than that, so he's certainly qualified. Additionally, the court in that case notably said that this is not going to be something where he says this is an exact location. Investigator Worrell explained that it's not an exact location. That's the same thing. Your Honor, in United States versus Adame, A-D-A-M-E, the 7th Circuit in 2016, the 7th Circuit just specifically said that this is a reliable science. The court found we recently explained the admissibility of historical cell site analysis under Federal Rule 702. We noted that historical cell site analysis can show with sufficient reliability that a phone was in a general area, especially in a well-populated one. It shows the cell sites with which the person's cell phone was connected, and the science is well understood. Your Honor, the Fourth Circuit similarly admitted this in United States versus McNeil, 763 Fed APPX 307. That's the Fourth Circuit, 2019. The court found that the district court did not abuse its discretion in concluding that the cell site location evidence satisfied Daubert's touchstones of relevance and reliability. The court also found historical cell site analysis has been broadly tested and accepted by the scientific community and the federal courts alike. Additionally, in United States versus Jones, that was the case I cited earlier, that was cited in Jackson. The District Court of the District of Columbia Circuit found that on the whole, the court is persuaded that the expert's proposed testimony is based on reliable methodology. Indeed, the use of cell phone location records to determine the general location of a cell phone has been widely accepted by numerous federal courts, and it cites to United States versus Schaeffer, SCHAFFER 439, Fed APPX 344, Fifth Circuit 2011, as well as district court cases from the Eastern District of New York and the Northern District of Illinois, namely United States versus Dean and United States versus FAMA, FAMA. Similar to the arguments that I've been putting before this court, the district court circuit in Jones explained that to the extent that Agent Eicher's testimony relies on assumptions about the strength of a signal given from a given cell tower, any challenges to those assumptions go to the weight of his testimony, not its reliability. Indeed, numerous other courts have concluded that the mere existence of factors affecting cell signal strength that the expert may not have taken into account goes to the weight of the expert's testimony and is properly the subject of cross-examination, but does not render the fundamental methodology of cell site analysis unreliable. So, Your Honor, we would ask that this court qualify Investigator Royal as an expert.
All right, I am good. Yes.
Before the court makes the ruling, I would like to make my argument first, please.
I gave everyone an opportunity, Mr. Hoover.
When I stood up and raised my hand, you went to Mr. Roosevelt.
You didn't.
I just, for the record, it'll be quick, it'll be simple, but I have to make the record clear.
Are you going to make any other objection that hasn't been made already?
I'm going to clarify.
Are the five or six areas that we've gone through already?
I want to clarify what my esteemed colleagues have said. Yes, for the record, I want to clarify because I see where this is going, and moving forward, not only with this expert, but the experts we've already dealt with and the experts moving forward, I just want to clarify the record of what.
All right, well, go ahead. Go ahead.
Your Honor, the issue that I have is there are two different ways, because you're the gatekeeper, that you need to look at this. Number one is the validity of the methodology. We're not arguing that at all. Validity is applied is the issue that we all have. And all I'm saying is this witness simply said he's testified this many times, he's done this for this many years, and that makes him an expert. We're not arguing that the methodology itself has a problem. The way he applies it is. Your Honor, in my 10 years of being a defense attorney, I've never gone to trial with the client and that client be convicted of a murder. Because I've done it for 10 years, does that make me an expert in murder trials? No. What we're talking about is this witness simply says he can't tell you what these cell sites are doing. He can't tell you what the cell companies are doing. All he does, he gets the information and he interprets it. Just because he's done it for however many years or how many times, they don't remember this thing to tell you that it's
offered for a particularized reason that the finder of fact is free to disagree or to agree with.
That's true.
Okay, and the case law is pretty clear. I mean, in terms of what the purpose of cell records can be, or records of this nature can be utilized for. So what's your specific other objection?
Simply because he's done it for so long, we can't tell the validity as applied to what he's done. He's actually done it correctly. He even told you there is no error rate. So at the point where he's supposed to give the jury information
to help them understand. Remember, that depends on the area of analysis. For example, if you're doing hard science like physics, chemistry, math, there's an error rate or other things that you can calculate.
True.
Okay, that's different than this type of science.
No, I agree completely.
But you have to look at each category that's being offered under Daubert as to the gatekeeping function.
True, but at the point where this witness can't tell you that the way he is applying the methodology does or does not have an error rate, at the point where this witness can't tell you the way he's applying the methodology that he's ever been wrong before, he cannot assist a jury if he can't tell you if he's right or wrong. All he's literally doing is reading a PowerPoint or reading an Excel sheet that comes from a company.
I think it's
all of us can do that.
I think it's more than that.
And that's why I said the argument is the validity as applied to this witness. That's the argument that my colleagues are making. That's the argument that I just want to make clear on the record. The state has never shown you anything where he can tell you that all of his experience tells you that he's done it correctly in the past, and that's why he can do it correctly now to assist the jury in anything. At this point, he can read an Excel spreadsheet, which every single other person in this room can do, so he should not be qualified as an expert for that reason. Okay. If they can go back in the past and say he's done it 700 other times or he has all this experience, and we can prove that he's doing it correctly then, and we can prove he's doing it correctly now, and we can prove that he can show the jury something that the jury can't understand on their own, then he should be an expert. But this is a validity as applied argument. He cannot show you that. I'm not an expert in murder trials. I'm not. He's not an expert in whatever the state wants him to be, because he can't tell you when he's been right, when he's been wrong, and he can't assist the jury in anything other than reading an Excel spreadsheet. That's the only argument I wanted to make.
All right. Based upon the arguments I've heard thus far, I'm going to qualify Mr. Worrell as an expert in CSLI and historical cell data, cell site information. All right.
Your Honor, if I could make a correction for the record.
Yes, sir.
In regards to my training, a total amount of post-training was 2,000 hours. I believe it was said that my training pertaining to this was beyond 350 hours. It is not. I don't know the specifics, but I just would like to make that clear.
Well, that's an issue that you can cross-examine him at trial on, okay? Okay, all right. And may Mr. Worrell be permanently temporarily excused for the time being?
Absolutely, Your Honor.
All right, Mr. Worrell, I'm going to permanently excuse you as a witness for the time being. The state will call you, or the defense will call you at a particularized time. Just make sure that they know your dates of availability, and we'll talk with you later, okay? Don't discuss your testimony with anybody except the attorneys in this case, all right?
Yes, sir. Thank you.
Right, thank you, sir. Okay, next. Call your next witness.
Yes, Your Honor. The state will call Mr. John Pulisic.
All right, Mr. Pulisic. Summon Mr. Pulisic, please. Mr. Pulisic, hold on one second. You step outside just a second, please. Just 1 second. Give me a second. All right, as it relates to Mr. Worrell, I just want to complete the court's analysis. I am under my gatekeeping function or required by Daubert and 702, going to find that he meets the threshold to testify as an expert in the aforementioned areas of CSLI and historical cell site data information. The basis for the court's ruling is his testimony on his training in digital evidence, digital forensics, the trainings that he's received by various agencies, the length of time that he has been in law enforcement. He has done well over 100 cell site investigations. He's been qualified as an expert 7 or 8 times in Fulton and Cherokee counties, and his methods are generally accepted. And he used this methodology to to look at the records or consider records of Javon Fleetwood. The court's also in agreement with the state in terms of United States versus Jackson, 2017 Northern District Court. That Ms. Rosenwasser just mentioned that there's a Lexus site that was already set forth on the record. For the aforementioned reasons, the court will, over the defense's objections, which will be noted for the record, allow Mr. Worrell to testify as an expert. All right, let's summon Mr. Paulzik, please.
Your Honor, make a very small request. I'm not trying to be a pain, but I know we're starting to get into a little more substantive witnesses, and I didn't take notes. I would like, if I don't consider this front row with a little table, I just need some space. It's very difficult to keep up and take notes while sitting on the bench, Your Honor, if possible. Your request. I agree, Your Honor.
I don't think I can help you out with that. I mean, we're doing the best we can in that respect. I wish I could do better for you on that, but given our configuration, I can't do that. You can ask, but I certainly this is the best we can do under the circumstance given the number of folks. Now, for trial, we will have tables commensurate with everybody's representation, but we're just trying to get through this period of time. So I have, in fact, taken that into consideration, but I can't help you out with that now.
I understand, Your Honor.
Okay.
And you know what the basics would have been, but
No, I understand, but, to the extent you all can use, lap desks or whatever else, or bring in other things that may help you to write, or use computer-aided computers in terms of take notes, that's fine. I don't have any issue with that. But in terms of tables or other things, I just don't have the ability to do that, given the security posture and the configuration of this courtroom. Have I addressed your concern?
thank you, Your Honor.
Thank you. All right, Mr. Matthews, thank you as well. All right.
Just ask one thing, please. Can we remind everybody to please use the mic?
Yes, ma'am. Yes, ma'am, we can. All right. All right, Mr. Paulzik, if you could, good morning, sir. I'm Judge Glanville. If you could please approach the witness stand. Once you get there, if you would be so kind and turn and face Lieutenant Gibson, be sworn as a witness, please.
Raise your right hand, sir, remain standing. Do you swear or affirm that the testimony you give in this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may lower your hand. You may be seated, sir. Watch your step. For the record, please state your name, spell your first and last, for the court and your occupation. Speaking to the mic.
First name is John, that's John. Pulisic, that's P as in Paul, Aulisick. I'm currently in private practice, serving as an examiner of question documents.
It's pronounce your last name one more time, sir.
Pulisic.
Pulisic?
Yes.
Okay.
Yes, Your Honor.
Thank you, sir. I appreciate it. All right.
Thank you. So, Mr. Pulisic, I know you said your job. Can you explain what the nature of your work is as an examiner of question documents?
Yes, as an examiner of question documents, I examine documents in order to determine the authenticity of documents. The examinations that I conduct, mainly in private practice, are concerning handwriting and hand printing. I also conduct authentication of documents with examinations of paper, ink, rubber stamps, staples, torn paper, anything that deals with the authenticity of a document will be the type of examinations that I will conduct.
Can you explain, when you say authenticity, what does that mean?
For example, in the area of handwriting or hand printing, I will receive documents of unknown origin, or we refer to them as question documents. And the question to me is whether or not a particular writer was involved. In the examination, I will examine that question document with samples also submitted that have been authenticated as coming from a particular individual. The samples, which are referred to as known samples, are basically of two types. One type of known document would be documents, normal course of business documents that have been authenticated as coming from a particular individual. The other type of known documents will be when an individual in person provides samples of his or her handwriting.
Okay. So I want to get into your job history and getting into this. How long, you said you're in private practice. How long have you been in private practice?
Approximately 6 years.
And what is your practice? Is that the purpose of it? What's it called?
Yes, my practice is Metro Forensics. It's an LLC practice. I have one partner in my practice. She is a retired document examiner from the Georgia Bureau of Investigation Laboratory, where she worked for over 20 years.
And what were you doing before you got into private practice?
I was functioning as a question document examiner for approximately 20 years, and that was with the Federal Bureau of Investigation. I was with the FBI for 34 years.
Okay. And did you ever do any work with the Georgia Bureau of Investigation as well?
Yes, after my retirement from the FBI, when I moved to Atlanta from Washington, D.C., I worked approximately 2.5 years with the Georgia Bureau of Investigation, working in their question documents section.
So would it be fair for me to say it's been over 30 to 35 years of experience in this field?
Correct.
Okay. Now, do you have any educational background to go into this field?
Yes, I received a Bachelor of Arts degree from Duquesne University, which is located in Pittsburgh, Pennsylvania, and I received a Master's of Forensic Science degree from George Washington University, which is located in Washington, D.C.
And did either of those degree programs address how to do this question document and handwriting analysis work?
Part of the discipline during my master's degree study at George Washington University dealt with the examination of question documents. I received my formal training while at the FBI laboratory, and that training consisted of a full-time 2-year program being trained in the discipline of question documents. And this was accomplished under the supervision of certified, qualified document examiners working within the laboratory.
And have you kept up to date with your training after that? Have you attended other trainings?
Yes, I received my formal training, as I testified, in the FBI laboratory for 2 years, and I also received additional training outside of the FBI laboratory in various areas. For example, in the area of printing, where I attended a week-long school with the Rochester Institute of Technology in New York. And I also participated in providing training while in the FBI laboratory to other question document examiners who were working at either the local or state level. The training sessions oftentimes were for a 2-week period for these examiners, and that was conducted at our facility at Quantico, Virginia. And it was a full-time training period for these examiners. I and another agent examiner provided this various training. And I don't know the exact number, but I trained mainly while working as an examiner in the laboratory, and literally over 100 different training sessions I provided.
And generally, what were the topics of the trainings that you provided?
Majority of the training was provided concerning handwriting examples. The attendees were provided various tests in handwriting, and also the majority at that time was training provided, excuse me, in the area of typewriting and also printing, such as printed documents coming from computer printers.
So have you kept up to date with the training as technology has developed over the last 30, 40 years?
Yes, I read various papers that are provided, and I also belong to an organization along with other examiners from the various parts of the southeast of the United States. The organization that I belong to is called SAFTI, and that stands for the Southeastern Association of Forensic Scientists.
Okay, and are you involved in other organizations as well, or have you been in the past?
Yes, I'm currently a member of the agency, the Society for Former FBI Agents. I belong to the local Atlanta chapter.
Okay. And have you ever testified before as an expert witness?
Yes, I've testified over 90 times as an expert witness. I've testified in 27 states throughout the United States. I've testified in 11 of the federal judicial districts, and in addition to the 27 states that I've testified in, I've also have testified as an expert witness in 40 different federal district courts.
Now, what have you been qualified in? What is the subject of your qualification?
The basic qualification and all of the written articles refer to the examiner as an examiner of question documents, or a forensic document examiner is the formal term used.
So have you been qualified previously as a forensic document examiner?
Yes.
And has that been in federal courts?
Federal, state, and local courts.
Do you only do work involving criminal cases, or do you involve civil cases and other work as well?
In private practice, I work both civil and criminal cases.
Can anyone hire you, the state, the defense, or an individual person?
Yes.
Okay. So just anyone who wants something analyzed?
Yes, but our policy in our practice is that we only accept cases where an attorney is involved.
Okay.
That's basically due to confidentiality issues.
Your Honor, at this point, I would like to show the witness State's Proposed Exhibits 13, 14, and 15. These have been provided in discovery.
What states 13, 14, and 15? Can you just enumerate them for the record, please?
Yes, Your Honor. States 13 is Mr. Pulisic's CV.
Okay.
States 14 is Mr. Pulisic's testimony list, showing the locations of his testimony.
Okay.
And State's Exhibit 15 is Mr. Pulisic's list of training received, and I have them here if any of the defense counsel.
Has it been provided in discovery already?
It's my understanding, yes, Your Honor.
All right. Any objection to states 13, 14, or 15? All right.
I object to stage 14. It does not matter how many times this man has testified. He can testify a million times if he wants to. It has to be with how he's applying what he did in this case at this time. I object to 14 because it can be 1, it can be 100. That's not relevant to what we are arguing and what we're looking at today.
Any further objection? All right. States 13, 14, and 15 are admitted over objection.
Mr. Pulisic, can you explain the method that you use to analyze these question documents, specifically if you're trying to compare a signature, determine who wrote something?
Yes, there are definite protocols and a methodology that's been established over the years. The examination, as I previously testified to, is comparing a document that is in question. In most cases, in my private practice, that deals with signatures, and the comparison is done with a side-by-side comparison. In other words, the question document is examined and compared to known samples that have come and have been authenticated as coming from a particular writer. The side-by-side comparison is a protocol that is utilized by all forensic document examiners. In my examinations, I examine, according to the protocol, I examine the known samples first before analyzing or examining the question. The examination of the known samples will be in order to determine the various characteristics that a writer inserts into his or her writing. The methodology is based upon the fact and the main principles of forensic document examination in handwriting is that no two people write the same way. An individual does not write exactly the same way twice. That a individual will insert characteristics into his or her writing that repeat themselves, and that lastly, that a writer cannot go beyond the skill level of his or her writing.
So is this, I guess, can you explain what is there a certain method to make these comparisons that you've learned or that you've been trained in, and can you explain how you make these determinations?
Yes, as I testified, the side-by-side comparison is the basic protocol for the examination, and the comparison of characteristics of a written document that is contained in the known handwriting, that these characteristics will repeat themselves. However, they will not be exactly the same. But when an individual is writing in a normal, natural manner, the characteristics will repeat themselves. And part of the examination that I conduct in both the known and the question writing, the basic starting point is that the writing is naturally and normally prepared without any element of disguise or distortion.
And when you say characteristics, can you kind of just give me an example of what a characteristic might be?
Yes, a basic characteristic will be letter formations that repeat themselves, connecting strokes that are naturally put into a writing, beginning strokes, ending strokes. All of these characteristics are general classic characteristics in normal natural writing. And the speed involved in the writing is important. Also, for example, the slant of the writing is important. And these are characteristics which an individual puts into his or her writing without really thinking about it. They repeat themselves, and it's part of their normal preparation of a writing.
Now, is this methodology, is this published anywhere, or is there anything been written about it, anything like that?
Yes, it's been part of the writing over the last century that has been put out in the examination of question documents and handwriting, and has also been established by the American Society for Testing and Materials, which is known as ASTM. The protocols and terminology used by question document examiners has been documented there. The protocols of the FBI laboratory are the same as ASTM, and also a scientific working group, which is known as SWIGDOT, has also established these protocols and the methodology for basic forensic document in handwriting examinations.
Now, is this the type of work that someone with no training or experience, me or ADA Smith off the street, could we just do this?
No, there have been one important study that was conducted by Professor Moshe Kam, wherein he provided extensive documentation and data relating to the examination of handwriting, both by qualified forensic document examiners and by laymen. The study resulted in an error rate of the non-trained, individual. Error rate was close to 60% of wrong conclusions, wherein the forensic document examiners that were involved in the study was less than 1%.
So that leads me to my next question. Is there an error rate when a forensic document examiner like yourself performs an analysis like this?
Well, in the FBI laboratory, when I conducted examinations as an agent examiner, every one of my cases was reviewed, peer-reviewed, by my unit chief, who was a certified question document examiner. Each one of those cases was peer-reviewed. Currently, if there's a case that I would like to have peer-reviewed, I will give it to my partner or to another forensic document examiner who I know and am aware of his or her capabilities.
Okay. Do you peer review everything you do, or not?
Currently, no.
Okay, but you have, the science itself is peer reviewed, is that fair to say?
Yes.
Okay. Are there standards to your industry or best practices?
Well, according to the methodology and the protocols, they are the same for every forensic document examiner, so that any document examiner that has been qualified as an expert, he or she will reach the same conclusion. In my examinations, I have a range of conclusions that I will provide in a formal written report. The range of conclusions will reach either a elimination of an individual or a positive association of an individual writer, or in between, depending upon the writing available to me, I may reach a lesser degree of certainty. And I have codified these limited conclusions as beyond identifying somebody with a particular writing. I may say that the individual probably prepared the writing, or to a lesser degree that the individual may have prepared the writing, or in between that, I may, based upon the writing that I have available, I may not be able to reach a decision one way or the other. On the opposite end of my continuum of terminology will be that an individual probably did not prepare a document, or may not have prepared a document. These are terms that I use in every one of my formal reports.
Okay. Now, is your method of question document analysis have you seen it accepted by other law enforcement agencies, to other agencies
Yes,
use it?
Yes, but the norm is that the individual examiner actually participates in a full-time 2-year program in a recognized forensic laboratory. And these laboratories are certified by a group known as ASCLD, which is an outside agency which certifies each of these laboratories.
Okay. And would you say that this form of question document methodology, is this generally accepted?
Yes, it is.
Okay.
Yeah.
Did you analyze any documents in this case?
Yes, I did.
When you analyzed those documents, did you provide a draft report and later a final report?
Yes, I did.
When you did that, did you follow the best practices, the methodology that we discussed earlier when you did that?
Yes, I did.
Okay. Your Honor, at this point, the state would move to admit Mr. Pulisic as an expert in the field of question documents.
All right, does anybody wish to voir dire Mr. Pulisic?
I do.
I'm Court Reporter Keith Adams on behalf of Jeffrey Williams. Mr. Pulisic, am I pronouncing that correctly? Pulisic?
Yes, sir.
All right, good morning, sir. Got a few questions for you, please.
Yes, sir.
I noticed in looking at your CV and the other documents that were admitted, I believe as States Exhibits 13, 14, and 15, if I'm correct, and by your testimony, that you currently are in private practice. You work privately with your own company, correct?
Yes, sir.
All right. You were last employed by the FBI in what year?
I reached mandatory retirement at the age of 57. It's a mandatory retirement for all agents. I retired in 2007, and after that moved to Atlanta, where I worked in the Georgia Bureau of Investigation Laboratory.
For 2.5 years, is that right?
Correct.
And so if I'm doing my math correctly, you last worked with the GBI in 2009, 2010 at the latest?
Yes.
When was the last time that you were qualified as an expert in the field that you've been tendered in?
I'm not sure of the date, sir, but it would have been a deposition where I worked a civil case.
Okay.
It would be within the last 6 months.
Okay. And that was, you were qualified as an expert for purposes of a deposition?
Yes, sir.
When was the last time that you were qualified as an expert in a court, whether federal or state?
I wouldn't know the exact date, sir, but we'd definitely be within the last year, and it would have been in the state of Georgia.
Okay, thank you.
Courtroom.
All right. State court, either superior or state in Georgia?
Yes.
All right. I wanted to ask you some very specific questions about, and just from a starting point, I think the last question, maybe the second to last question you were asked by the state was whether or not you were asked to review and analyze a particular document or documents in this case.
Yes, sir. Yes, sir. I received 2 submissions relating to the same subject.
Okay. The subject would have been Jeffrey Williams.
Correct.
All right. When did you receive those submissions?
If I could refer to my notes, Your Honor.
Please do.
You can.
With the court's permission.
You can, sir.
Okay, the first submission that I received was June 28 of 2022. And the second submission was received December 9th of 2022.
Okay. First submission in June of this year, second submission in December of this year, maybe about a week and a half ago or so. Does that sound about right?
Correct.
Right.
Yes.
Again, as a starting point, you use the method or the methodology that you referenced earlier in analyzing these documents that were submitted to you?
Yes, sir.
Your ultimate conclusion to use your scale, I'm going to use that word, is that you made a determination that Jeffrey Williams, quote, probably prepared the documents that were submitted by you, or to you, correct?
Yes, sir. That was part of the report dealing with the first submission that I received. The second submission that I received consisted of 3 documents that were originally provided in the first submission. So the second examination of the second submission, the results were the same as the first because the documents were obtained by me with the first submission.
Okay. Now, in regards to the documents that were submitted and your methodology, am I correct that you indicated in the testing of these documents that your ability to make any sort of definite determination was limited? Is that true?
Yes, I reached a lesser than full identification of the individual writer.
Okay. And so I want to ask you about what you've referred to. We talked about error rate a little earlier. Right? So I want to ask you about the error rate and the potential error rate specifically in the examination of these documents that are at issue here. Okay? Did I hear you correctly to say that when you worked with the FBI, your work was routinely peer-reviewed?
Correct.
All right. Did I hear you to say that every case was peer-reviewed?
Correct.
All right. And the importance of peer review is what exactly?
It is to ensure that the results in my report are accurate and were reported according to FBI protocol.
Okay.
And the examination, if in question, would be peer reviewed by not only my unit chief, but also another qualified document examiner within the lab.
Okay. And again, the importance of that peer review is to make sure that protocols that you've referenced previously and that are utilized, that are part of best practices, are followed. True?
Yes, the peer reviewer would utilize the same protocols and the methodology that I used and were taught to me during my 2-year training period.
In the examination of the documents that are at issue here, that was submitted to you first in June of this year and then again in December of this year, were your results peer reviewed?
No, sir.
Okay. So no one peer reviewed the results that are at issue in this, that we're testifying about here today, correct?
While in my private practice, I will ask for peer review if in fact I have some level of uncertainty as to my results prior to my putting the results in a formal report.
Okay. Am I correct that in the document that you've provided, that is again, I'm going to use the term sliding scale, your degree of certainty as controlled by the protocols that you've discussed previously go from where someone definitely, or a document is definitely prepared by the same person, correct?
Correct.
All the way down to definitely not prepared by the same person.
Correct.
Right. In between those two extremes, those two certainties, probably are prepared by the same person. Under that is may have been prepared by the same person. Under that is no conclusion could be reached as to whether they are prepared by the same person. Under that is may not have been prepared by the same person, and then probably are not prepared by the same person. And then, of course, the last one, definitely not prepared by the same person, all right?
Correct.
All right. So I want to ask you a question then about what we discussed earlier about error rate. You testified to the court that in studies that have been done, comparing a non-trained individual to a trained individual, that the error rate for the non-trained individual in the examination of question documents would be about 60%. True?
During that study, that particular study, yes, sir.
The error rate for a trained document examiner with specialized knowledge was less than 1%, correct?
Correct.
Now, is there a difference in the error rate? If we're looking at, for example, you reach a determination, and this is hypothetical, you reach a determination that a document is definitely prepared by the same person. Right? There presumably would be an error rate in that analysis, correct?
Yes, there would.
All right. Would the same error rate apply when you come to a determination that a document is probably prepared by the same person? Or is there a higher error rate?
Mr. Adams, I won't interrupt you. I hate to do this, but this is weight sufficiency cross-examination at trial.
Well, it goes to the witness's ability to testify about error rate, and specifically because the error rate or the determination made here
in terms of question document examiners, this is the language they use. You can ask them that language and its meaning at trial, but it doesn't invalidate the science behind this or an issue or go to your question doesn't go to my gatekeeping function, put it that way.
Your Honor, the science
to weight more than sufficiency.
The science behind it is one thing. But as been stated previously, whether or not the methodology was properly used and whether or not there is an error rate, because that is one of the things that Daubert and 702 says that the court has to consider. What is the error rate? And that's exactly what I'm asking the witness.
No, it doesn't. I beg to differ. No, it does not. It does not specifically say I have to use the error rate. In Daubert, I'm required to look at 4 things, and also depends on what type of examination or what type of science that you're asking me to look at or consider in my gatekeeping function. But I got to consider whether the expert is qualified to testify competently regarding the matters that he intends to address, the methodology by which he reaches his conclusions are scientifically reliable. The 3, the testimony assists the trier of fact, to understand the evidence, determine fact and issue. Proponents may establish an expert's qualification in many ways, including scientific training, education, experience in a particular field, but there's no mechanical checklist for measuring whether an expert is qualified to offer an opinion in a particular field. When necessity, reliability, and methodology expert employs, the court considers the methodology, testability, error rate, Mr. Mayor, and peer review and publication and general acceptance. I'm not bound by that, but I look at those factors.
Yes, Your Honor, and that's my point exactly, Judge. Daubert does in fact say, in citing to United States versus Smith, 869 F. 2nd 348, 1989 case, Daubert does in fact instruct the court that, quote, additionally, in the case of a particular scientific technique, the court ordinarily should consider the known or potential rate of error. I'm not suggesting that
is one for the particular field.
Yes, sir.
Okay,
and that is what the witness has testified to, and he's testified under direct about error rate. And so my inquiry goes to whether or not there is a difference in expected or anticipated or known error rate when a particular conclusion is reached, as in this case, where the determination is probably prepared by the same person as opposed to definitely.
Okay, but that's different. That's QD. That's question document examiner language. That does not. I disagree with you, sir. The court has from question document examiners, and Mr. Paulsick has told you that these particular types of terms are terms that he uses in his profession or trade. that go along with him being able to reach a conclusion, which you can test. So, and it'll go to weight versus sufficiency. Now, Mr. Polisic, are these maybe I'll just clarify that before I let you answer a question, asking any questions. Mr. Polisic, are the explanations you gave as to the types of conclusions that you give, are they standardized in the industry or the scientific field of handwriting or question document examiners?
Yes, Your Honor.
Okay, all right. So, he's testifying about what QD question document examiners utilize in terms of their particular trade of responses. So, those are acceptable. You're going to have to ask him at trial about those, or you can kind of wrap it up in terms of this, but that's what he's testifying about.
Thanks, Judge. And if the court's position is that I cannot ask that specific question that I was going to ask about.
Well, go ahead. But I'm telling you right now, I'm trying to get it why you're asking that question, okay? And I want you to, I want to make sure, because neither one of you brought out that is the language of a question document examiner. They utilize this, and I just want to make sure I didn't put words in his mouth or say something that hasn't been kind of brought out before. But that is that question document examiners, when they testify, this is the language they'll give you, and it has a certain meaning. If you want to, so if you can continue at this point.
Yeah, and I'll ask just so I can. I think the answer to that question would give the court additional factors to consider in regards to the methodology. And so, Mr. Polisic, do you remember where we were in terms of what I was asking you? I was asking about error rate. And in this particular case, your determination was that this document was probably prepared by Jeffrey Williams. Right? And my question then is there a different analysis for error rate when you reach that conclusion versus when you reach a more certified conclusion of definitely prepared by the same person? You understand the question?
Partially.
Okay.
The error rate does not pertain to the terminology that I utilize in my results of an examination. In addition, while I worked in the FBI laboratory, we were extremely conservative in our conclusions. In other words, in my degree of certitude is defined by my terms, and those terms have been codified by the agencies which I previously testified to, the FBI laboratory, ASTM, and SWIGDOT. These terms are utilized and codified in written publications by not only those agencies but also by other forensic laboratories.
Okay. In regards to this particular analysis, you've testified previously that these results, both the ones from June of this year and the one from December of this year, were not peer-reviewed. Is that correct? I think you've testified to that previously. Is that right?
Correct.
Can you explain to the court why they were not? If the object is for accuracy, why were they not peer-reviewed, given your previous testimony about the necessity or the importance of peer review, certainly while you were at FBI?
Well, my conclusions, specifically in this matter, were certain in my mind as far as an examiner of 30 years. I would have, if I was not able to reach a conclusion, I would have utilized the middle term of my continuum, as I cannot determine one way or the other whether or not an individual writer prepared a question document.
When was the last time that any of your work was peer-reviewed?
It would be within the last year, but I'm not certain as to a date. What I routinely do is, if I am uncertain as to my findings, I will ask my partner to review the evidence that I've received. and I will provide my partner with the submitted documents without giving what results I've reached in that matter. The peer review would be strictly done by my partner, all alone by herself.
All right. But that was not done here?
No, sir.
In regards to the accuracy of your conclusions, is it true that you indicated that your initial analysis was done based on photocopies of documents?
Correct.
Was your second analysis, the one done in December, were those done from original documents?
No, sir.
Okay. So they're both done from, those analyses were both done from documents with photocopies of signatures or writings, is that right?
Correct.
And if I heard you correctly, the accuracy or your ability to make a definite determination is going to be limited based on analysis of photocopied documents.
That's correct. A photocopied or machine-generated document is a two-dimensional document, whereas a original document is a three-dimensional document, which lends itself to additional exams such as writing pressure involved, the writing ink that may be involved. So the limitation, excuse me, the limitation of the machine copies or photocopies somewhat limits the possibility of a positive association. However, I have associated machine copies or photocopies in previous cases and either definitely identified or associated with a writer or eliminated a writer. It is possible.
All right. Thanks, sir. Those are all the questions I have.
Anybody else?
I have a couple questions, Your Honor. Sean Holmes for Antonio Sumlin. Since you've been in private practice, how many sufficiency tests have you taken?
While in private practice?
Yes.
None.
Okay. So there are no mandatory peer reviews now that you're no longer with the feds, now that you're in private practice, and you don't take any more proficiency tests.
Correct.
Correct?
Correct.
All right. So this methodology that you're using, it's subjective, correct?
No, it's codified, and all forensic document examiners follow the same protocols and methodology.
Well, let me put it like this. You as an examiner can notice something that gets you to a resolution, right? That's what you do. You notice certain things in handwriting that gets you to the conclusion of this person wrote it, this person didn't write it, or in between, correct?
Correct.
Another examiner, not your partner, not in your office, just another examiner, can get to the same conclusion but noting different things in the handwriting. Is that correct?
I wouldn't be able to determine whether or not they were not utilizing the same samples that I did. A qualified examiner would receive the same documents that I received and would observe the same characteristics that are utilized by qualified examiners.
Sure. But you don't know if the other examiner noted every single thing that you did to get to the conclusion.
Mr. Hoover, that's kind of misleading because he's testified if he doesn't feel comfortable with it, then he submits it to another examiner. You're asking the other question, the converse of that.
Well, then let me rephrase. I apologize.
Okay, all right.
If you only peer review it when you don't feel comfortable and you don't take proficiency tests and you're basing it off of what you believe is true, how do you ever know you're wrong?
Well, I'd be unable to determine if I was in error. It's still my expert opinion, and the opinion in most courtroom situations, I would prepare a demonstrative chart outlining characteristics that I observed or did not observe, so that the jury or the judge would be able to look at that chart, demonstrative chart, and observe the same characteristics which I did during my examination.
So in that long answer, I believe you just said that you don't know if you're wrong. That's what, you don't know if you erred or not.
No, I would have no way of knowing if I was wrong.
No further questions, Your Honor.
Anybody else? Okay, all right. Any argument?
Yes.
I'm going to ask the court not to qualify this witness as a certified document examiner or whatever was proffered by the state. I understand Daubert, I understand 702. As my esteemed co-defendant's counsel has stated previously, methodology is important, protocols are important, but the application of that methodology in this particular instance is what the court should consider in regards to whether or not this person is qualified as an expert. And what I got to keep harping on is we start from a standpoint that this was not a certified resolution. He did not come to a conclusion that this was definitely this person. And so given that we start with some degree of uncertainty, saying probably is an uncertainty, given that we start there, the question that we...
Let me hijack you. I'm going to hijack you. Probably is a question document examiner's term that you can cross-examine him on when it goes to weight and sufficiency. All question document examiners utilize the same language.
The word probably...
Okay, we're going to just disagree on that one, okay?
Well, and that's fine, Judge.
Mr. Adams,
that is...
Given his field and trade, that is what he's testified to. It does not have the meaning that you comport it to. So, unless you've got some other methodology, I'm waiting to hear it.
Let me continue with my argument then. Yes, I would start. My argument was that given that we start from a determination that, using the word probably, the court has to take a look at whether or not the Daubert standards are met. And what Mr. Hoover said was that exactly, the question goes to the point. He is unable to determine if he is wrong. This is an analysis that was not peer-reviewed, and the witness started by talking about the importance...
Yeah, but he told you why it wasn't peer-reviewed. That goes to weight.
Well, no, he did not explain why it was not peer-reviewed.
Yes, he did. I'll tell you the answer right now. He said it's not peer-reviewed because he's comfortable with the analysis that he made.
Right, and he's comfortable with the analysis that he made, but he does not...
Given his 30 years. And then he said if he wasn't comfortable, he would get another examiner to go, usually his partner, to go ahead and do that. He didn't feel he needed to do that in this case, and when he was with the FBI, he had the mechanism doing that.
Subjective to belief as to whether or not they are accurate or not is not, and then deciding, well, I'm not going to have it peer reviewed because I think it's fine, is not a scientific method. A subjective belief is not a scientific method or the use of scientific methodology. I would simply, the witness explained in detail about his time at the FBI, his 20 plus years, his time at the GBI, and the importance of peer review and why that was important. But in this case, in this particular case where determination is made, it was not peer reviewed, and that is certainly something that the court ought to consider as to whether or not he ought to be qualified. Not just whether or not this science is acceptable. Yes, the science is, or the methodology is acceptable. It's been acceptable in courts previously. But as applied in this particular case, are the factors that Daubert and 702 require applied in this case such that he should be qualified as an expert? Well, I simply would contend that he's not met those standards. That is an extremely important portion of whether or not the science should be acceptable and whether he should be qualified as an expert. I would contend that he should not be.
Okay. Thank you, sir. Mr. Hoover.
Yes, Your Honor.
Mr. Jones, I got you next, okay? All right.
Sean Hoover again for Antonio Sumlin. And Your Honor, I have to make this clear. Regardless if we're talking about 702, regardless if we're talking about Daubert, regardless if we're talking about Kumho Tire, it all comes down to two things. Reliability in the methodology and reliability as the way this person applied it. As the gatekeeper, you have to determine that what goes to a jury is reliable. I have to disagree with what you said because the witness literally just said, I'm right because I think I'm right, but I don't know if I'm ever wrong.
That's part of the examination for you. I mean, he's testified that's the methodology and that in terms of how he and why he is not peer reviewed this particular issue. So I mean,
Your Honor, the reason we go through these hearings is because the state is trying to qualify this person as an expert, which puts him above a layperson, which puts him above an officer.
I understand.
The expert is supposed to be able to apply information or give information to a jury for them to understand something they can't understand. So at the point where the witness says, I don't know when I'm wrong, how does he tell it or give information to a jury for them to understand anything else?
If he's wrong, which he says is not able to make a determination or a conclusion, then of course he would then at that point in time have it peer reviewed. But he's comfortable with his particular analysis, so that's why that's the explanation, and that's utilized in his field or trade of occupation.
And I think you are missing the reliability part of this. The point is, he doesn't get to go to open that door and walk through as an expert until we know that the way he did something is reliable. Simply because he says he knows it's done.
Okay, remember. This is the science of fingerprinting, or I should say, of question document examination.
True.
Expert threshold. All those things you're mentioning right now go to when he comes to trial and he presents the standards, when he presents against a known versus question document. All the things that you're saying are perfectly clear and can be examined.
True.
Don't disagree with it at this point in time, okay?
Yes. The problem is that's not 100% true. The court has to look at reliability of the methodology and reliability of the person that is applying the methodology in this case.
Testability, error rate, peer review, and publication, and general acceptance. Those are the factors that I look at, okay? So they're factors, okay? There's not a hard and fast rule. I know that you keep harping on this, and I understand that you're doing your job, but I'm just telling you at this point in time, it certainly goes to my gatekeeping function, but it certainly as well goes to your ability to examine this particular witness. Should he be called to testify at trial?
And just to make the record clear, I object to this person being qualified as an expert under the validity as applied reliability standard that the court must consider before he becomes an expert.
I'm saying I have, and I'm telling you, I have applied that, okay? So, Mr. Jimmons, go ahead.
Good morning, Sudi Chada Jimenez, on behalf of Mr. Dorsey, and just want to lay out my argument, and I don't mean to be repetitive. I'm just trying to keep my thoughts together. It is hard. I'm trying to
Well, see if you can bring up something new that hasn't been otherwise articulated by Mr. Adams and Mr. Hoover.
Absolutely.
Okay.
Yeah. I just want to make it, we all know that the new rules of evidence that have been applied, we've adopted in Georgia a few years ago, federal rules of evidence, they tend to lean towards admissibility. It is something
The federal rules as a whole do.
Yes, yeah. and in Georgia, we want the jurors to see the evidence, to hear the evidence. We want them to, if something goes to prove that a fact is more likely or less likely, then it's relevant, and we want them to hear about it and make a decision. I do want to make a distinction, Daubert and Kumo. It kind of goes the other way. That's what gatekeeper is. Gatekeepers are these young men with weapons and vests and tactical gear. They're keeping the gate from making sure that we don't get rushed by a bunch of public and silly people that are going to make phone calls and do stupid stuff on Zoom. They're the gatekeepers, because we don't want all of that, because that's irrelevant. That has nothing to do with this case. And that is your role, Your Honor. Respectfully, that is your role, to make sure that some of this stuff doesn't just come in because the state wants it and bolsters it. Experts have a different standard. An expert can testify as to hearsay and stuff that they haven't seen or done themselves. They can give an opinion. Why? Because they're experts and they have the experience. There is no doubt that this man is, Mr. Polsnick, I apologize, sir, is an expert. He has had the training. He has had the experience. He has had peer review. Most importantly, and the state went really into detail with this. And you know why? Because it matters. He knows the methodology. We're not talking about hard science. We're not talking about chemistry and physics. We're talking about handwriting, but you know what? I can't tell. If you show me like some scribble, I don't know if it's Mr. Williams' signature, it might be former President Trump's signature, just a bunch of squiggly lines. We need somebody like him to tell us. But here is the key. Again, Your Honor, I'm referencing mostly Kumo Tire versus Carmichael, that's 526 U.S. 137, 1999 case, Supreme Court. What it said is pretty much, you know what? The Dauber standard, you can't just apply it to hard science. You're going to apply it to anything else that requires a certain level of expertise that a lay person cannot understand, because that's the key. Can you please explain to everybody else what it is that you have studied so hard for? But you have to do it right. It's like a recipe. It's like making a cake. I ain't no expert, and I'm not a chef, and you can give me all the ingredients. You can give me a bunch of flour and eggs and whatever. You give it to me, I don't know what to do with it. You know what I have to do? I have to follow a recipe. There is a methodology, step by step. And he has testified that there is a methodology that exists. And when he was under the supervision of the FBI, the federal government, somebody with standards and somebody wants to make sure things are done right, he followed it. Part of that was peer review. So, I just want to say that. Yes, Kumo says that scientific knowledge is not the only thing that we're going to apply to the Dauber standard. We're also going to apply it to technical and other specialized knowledge, like this. It is flexible. Let's remember that Kumo was not about letting everything in. Kumo was actually about a case about the expert that the plaintiffs wanted to put up and say that he knew why the tire exploded, because either this happened, and if that didn't happen, there's a manufacturer error. And you know what? The defendants were able to get that suppressed because he didn't apply the science correctly. He didn't do what he said can be done. And then, they went up to the Court of Appeals and Supreme Court. They're saying, no, you can't use the Dauber standard on him because he's not a scientist. Supreme Court just said yes, and the discretion is the discretion for the court not to let it in. Not discretion for let's just let everything in and let a jury determine as to weight and admissibility. No, we want the jury to not waste its time with all these fancy titles.
But you'd agree that handwriting has been around 100 years.
Absolutely.
So is there any, how would you address that?
Handwriting has been around 100 years.
And question document examination of handwriting.
And it was not, the methodology that he knows was not applied in this case. And a lot of the other experts, I'm just going to make my argument now because I don't want to have to keep standing up for the same exact point. You have to apply.
Welcome to do so.
Yeah, you have to apply the methodology that you claim it is. Some things don't have a methodology. Some things you just know how to do, and you use certain tools, or you have the education, but they're just not a recipe. But in this case, he testified there is, and he testified he chose not to use it. Because one of those things, as he had said, why, Mr. Adams asked, why peer review? To ensure results are accurate and done per protocol. Protocol. What is protocol? You have to follow the steps. You have to follow the recipe. Why do we have protocols? Why do we get up and accuse police officers of violating people's civil rights because they didn't follow the standard operating procedures? The protocols. Follow your protocols. Follow your own rules. Follow the rules of the science that you should be respecting. That they exist for a reason. They're not just there to CYA. No, they exist there because you want to make sure it's done right. Whether it's for the government or for the defense or for some tire company, you want to make sure it's done right. So, and I'm sorry, again, I'm trying to keep up with my notes, but no desk makes it a little difficult, so
do the best you can.
My apologies.
All right.
I just want to emphasize, Dauber, it establishes a standard of evidence reliability which requires a valid connection to the pertinent inquiry as a precondition to admissibility. We are trying to determine not whether or not the science exists, not whether or not he's an expert at the science, but did he follow the steps properly as a precondition to letting a jury hear from him as an expert. That's my entire point, Your Honor. You can do whatever you can talk about any sciences you want, you can bring in all the experts you want, but just make sure they do it right before we do all of this dance in front of a jury that's just going to be confused if you didn't do it right. Yes, it goes to weight and admissibility, but it also goes to the gatekeeping. Don't let the jury hear stuff that was done improperly. Let them hear the good science. Let them hear about the proper experts that follow their methods. Don't let them just hear about anybody just because they're an expert. It's not a question as to is he an expert. It's a question about did he apply his expertise properly to this case. And my last point, Your Honor, I think it's not part of the order, but late Justice Scalia, which always, his dissents are always very on point. I think it is worth adding, it is not discretion to perform the function of whether it's inadequately, I'm sorry, I apologize. I think it is worth adding that it is not discretion to perform the function inadequately. Rather, it is the discretion to choose among reasonable means of excluding expertise that is false and science that is junky. But if there is a science, let's use it. If there is a recipe, follow the recipe. Don't just throw everything in the blender and then toss it in the oven and hoping that you're going to get a 3-layer cake with beautiful and tasty results. Because that just doesn't happen. You have to follow the steps, Your Honor. Thank you.
All right. Ms. Rosenwasser?
Nobody else?
I think you're good.
I mean, I got more.
You're kind of inadequate now that he made a cake analogy, right? Yeah, you feel bad about that, don't you?
I do.
Okay, all right, okay. Go ahead, Matt.
Well, Your Honor, I don't know much about cooking, but I do know that the law supports the admission of this expert. That's what I do know. Your Honor, so first of all, I want to start. I think the defense may have gone a little astray. The peer review factor goes to whether the science itself is peer reviewed, not whether he has had his item peer reviewed. If Daubert required every expert to have whatever they did peer reviewed, that would mean that by law, every case would require to have 2 experts to have anything admitted, and that is certainly not the state of the law, whatever it has to do with cakes or not. And Your Honor, the law is very clear that his science has been accepted in the 11th Circuit. Your Honor, the leading case on this out of the 11th Circuit that I found is called United States versus Paul, P-A-U-L. That's 175 F3D 906. That's a 1999 case out of the 11th Circuit. And I want to point out that it's been upheld several times, but I like to point to that one as the leading one. In Paul, specifically, a defendant challenged a handwriting analysis similar to Mr. Pulisic here, and the court specifically said his argument is without merit. The court in Paul said, the Supreme Court stated that the inquiry envisioned by Rule 702 is, we emphasize, a flexible one. And Rule 702 assigns to the trial judge the task of ensuring that an expert testimony both rests on a reliable foundation and is relevant to the task at hand. So is the expert's testimony relevant to the task at hand? Oh, it certainly is. And is it based on a reliable foundation? And that's when we ask about the peer review. Is handwriting analysis something that's based on a reliable foundation? Your Honor, it certainly is, and Mr. Pulisic explained that, and he explained his vast qualifications to testify about it. Your Honor, specifically, the court in Paul found that handwriting expertise will assist the trier of fact, and further, they found that this was an admissible form of testimony. And Your Honor, in United States versus Dale, which was an 11th Circuit case in 2015, the cite to that case is 618 Fed APPX 494. In that case, a handwriting expert's analysis was admitted as an expert. In that case, the court found that that expert was properly qualified. The court found Miller was properly qualified as an expert. He had been a forensic document examiner with the IRS for over 10 years. He had examined approximately 100,000 documents in his career, and he had twice been previously qualified as an expert in document examination in federal court. He was also certified as a forensic document examiner, just like Mr. Pulisic has told us about. Additionally, in Dale, the court then found further Dale's assertion that handwriting analysis is not reliable scientific evidence is without merit and has been squarely foreclosed by this court's precedent. And it cites to Paul. And finally, the court found that this testimony was helpful to the jury in understanding the handwriting samples. So, Your Honor, when we look at the applicable law, and that's just the 11th Circuit, I have about, 10 10 cases from other circuits too. I'll just provide the cites to those. We have United States versus Crisp in the Fourth Circuit. That's 324 F3D 261. In the Fourth Circuit in 2003, that court found that handwriting has a long history of admissibility in courts in this country, and even said the fact that handwriting comparison analysis has achieved widespread and lasting acceptance in the expert community gives us the assurance of reliability that Daubert requires. To the extent that a given handwriting analysis is flawed or flimsy, an able defense attorney will bring that fact to the jury's attention, both through skillful cross-examination and by presenting expert testimony of his own. So, Your Honor, I think that's what the court was responding to during the cross-examination and some of the arguments. To the extent the defense wishes to say, he's wrong, he doesn't know what he's doing, even though he's done this for 35 years, he clearly is bad at this. If they want to say that, they are more than welcome to explore that on cross-examination, or they're more than welcome to bring their own expert in here, have him do his own analysis, and I can challenge their expert the way that they're challenging Mr. Pulisic. That is absolutely an appropriate way to challenge this. But to say that he's not an expert and that this is not an acceptable field under Daubert is just a completely specious argument, Your Honor. In Faust, United States versus Faust, F-O-U-S-T, 10th Circuit, that was just last year, 2021. The cite to that is 989 F3D 842. The court specifically found that this comparative process has widespread acceptance. It says, and given the widespread acceptance of handwriting comparison throughout the years, we find this factor supports the admissibility in this case. It further finds handwriting comparison is not a traditional science, and the Daubert factors do not always correspond perfectly, but it found that this was absolutely appropriate expert testimony. Similarly,
I think we're good.
I will cut off, Your Honor. Thank you.
I think we're good. All right. Okay. The court has had an opportunity to take a look at United States versus Paul, 175 F 3rd 906. It is a 11th Circuit Court of Appeals case. Relevant portion, it does in fact indicate that handwriting analysis is admissible under Daubert, but specifically as to Mr. Pulisic, the courts considered his testimony as well as states 13, 14, and 15, particularized his he's been in private practice for the past 6 years. Prior to that, 20 years with the FBI, 34 years as a federal employee, 35 years in the field, a master's of forensics from George Washington University, worked at our Georgia GVI laboratory for 2.5 years as a question document examiner, belongs to CFIS. He's kept up with the changes in documents. He's testified as a examiner of question documents some over 90 times, 27 states, 11 federal districts, 40 federal courts, state courts, civil and criminal cases. He is familiar with the standards of the industry, best practices. He utilized those particular practices in the comparison of documents in this case, and for the above mentioned reasons, the court is going to admit him or allow him to testify as an expert, as an examiner of question documents, subject to other foundation that maybe need to be admitted in this case. All right. Ms. Rosenwasser, who do you have next? I think you have Dr. Henninger, is that right?
Your Honor, we have
and Mr. Bernie
outside, and I think we're getting Dr. Henninger right now. He's already here or about to be here, but we have Mr. Bernie ready to go.
Okay, let's take 10 minutes to begin with, and just take a comfort stretch break, and we'll go ahead and get Mr. Is Mr. Bernini here?
Mr. Bernie is here. And
okay, all right, we'll cover Mr. Bernie next, okay?
Your Honor. Your Honor.
Yes. Yes, hold on 1 second.
I'll be excused, Your Honor.
No, you can't. Now, yes, but of course, sir, you may be excused. You're free to go, sir. Usually do these avocations. Just don't discuss your testimony with anybody except the attorneys in this case, okay? Yes, and we'll call you when we need you, all right?
Okay. Thank you, Your Honor.
Okay, you're very welcome. Go back on the record for just a second. Given the hour right now, let me just go ahead and break for lunch. It might be prudent to send everybody lunch and let everybody eat lunch. So let's reconvene at, the time right now is 12:45 or ish, 12:47. So let's everybody reconvene at 1:47 with an anticipated start time for 2 o'clock. All right? All right, so we're in recess until that time.
See.
I did, that was confirmation, he got another case, not the actual case. Take a second. Oh, third circuit. It looked very short. Yeah. He was first.
I know it's right. Just go get it, sir.
I've got it. So.
Well, let's go back on the record, council, interested parties, thank you.
All right, Ms. Rosenwasser, who do you have available at this point in time, madam? Do you have both Dr. Henninger and Mr. Bernini?
Yes, we were hoping we could take Dr. Henninger first.
Let's do that, that's fine.
And, Your Honor, I was wondering, just for scheduling purposes, does the court still want us to have Investigator Hall here after?
He was supposed to be here anyway, so.
He got his way, we just didn't want to.
Then why are you asking me about that?
If people, okay, I'll make sure.
I mean, look, in all seriousness, I'm just, we'll see how things go, but as long as we can take care of these other two witnesses, that's fine, and then we'll see how much time, or see what the day leads us or leaves us with. Related to your schedule, madam, do you have the three witnesses or is it one witness for Mr. Farley's three remaining motions?
Your Honor, it's three witnesses. They are available on the 28th, and then.
No, I thought you said you were all going to do those. Oh, you did say the 28th. Yeah, that's right. I apologize.
The
Yeah.
motions I can do today for Mr. Farley is he has two. He has a constitutionality motion, and he has another demur. No witnesses are needed for that.
When did he file those?
They were filed on the 22 pack. It was just the 2 that I handled that Mr. Floyd didn't handle, so we said we could do those anytime. I can do them now. Or,
Yes, ma'am, okay.
And the other 3 evidentiary motions need the 3 witnesses.
That's fine.
Who are available on the 28th.
Okay.
And, Your Honor, I also spoke with Mr. Adams this morning. Mr. Adams was discussing his client's motion to suppress, and I believe he may also wish to be heard on the 28th. And our witnesses could be available that day as well. So we were just curious if we could get some guidance from the court on whether to have those out-of-state witnesses come in again.
That's the motion to suppress that was begun previously with the out-of-state witness. Motion to suppress statement from DeKalb County. Mr. Steele had actually begun that motion. I anticipated he wouldn't want to conclude it, but he'll be back on the 28th. He'll be.
That's
here.
fine.
If we can do it in the afternoon of the 28th, with the court's permission, that would be fine.
Okay. All right.
The only other issue, Judge, is in regards to this afternoon. One of the witnesses, Mr. Burney, is going to be called, I guess, after Dr. Henninger. We're going to object to him being called. I think I speak for myself on behalf of Mr. Williams as well as the other defense attorneys.
All right.
Mr. Burney is going to be called as a cell phone location expert. My understanding is that he has not prepared an actual report, but is in the process of doing so. We would object to him testifying prior to him completing that report and letting us have access to it, since that essentially is going to be the subject matter of his testimony or his qualification. We don't have any objection to him testifying at some later point when he's done with the report and we can actually have access to it, but I think it's counterintuitive to have him testify and try to be qualified now on something that he's not completed yet, that we would need in order to properly cross-examine him or voir dire him.
All right. Madam?
Your Honor, Mr. Adams is absolutely correct. He has not finished his report yet. However, we brought him here today. We had the Daubert hearing scheduled. We believe that it would be appropriate. So there's different prongs of Daubert. It's whether the person's qualified to offer the testimony, whether the science itself is reliable, and whether the application, whether they have reliably applied the reliable method to the thing they actually tested. So if the court would like to reserve that third prong for later, we can present the evidence on the first 2 prongs today and simply revisit this at the time his report is created, or, I mean, we will ask him if he plans to, of course, reliably use his methods. But he's here. He traveled from Alabama today. We thought perhaps we could at least get his qualifications and the reliability of the methodology itself on the record today. And if the court wishes to reserve its ruling until immediately prior to his testimony at trial, or until the report's created, that's fine with the state, Your Honor.
We'll be guided by whatever the court decides. It just seems a bit counterintuitive to kind of have him start testifying and then bring him back. And here's the other thing, just from a practical standpoint, let's say he gets qualified as an expert, but then the report doesn't come in for whatever reason. And then it's kind of, we're going through the exercise for nothing. It just seems to make sense to have him come when the report's done and we can just kind of do it whole hog, if that's a phrase.
Okay. Madam?
Your Honor, again, I'm going to reiterate my request. He's driven in here from Alabama. We'd like to just put the first 2 on the record so that if we...
Well, why did you have him come today then? I mean, it does sound counterintuitive that he would probably at least need to be able to testify, hey, I did this particular test with these in this particular manner, and I followed these particular, these methods. Consistent like your other cell phone expert did. When's he going to finish his report?
Should be fairly soon, Your Honor.
And then it's got to be provided to the defense.
It will be.
So I think it's probably a little much. Yeah, it's probably a little bit probably not ripe quite yet. Yeah.
Premature?
Yeah, ripe. That's what I was looking for.
What else were you looking for?
Yeah. So let's just you can explain to him that that it would make better sense if we did that. And maybe you can ask him when his report's going to be due, because we can. I mean, if worse comes to worse, I can always take it before he testifies. I can qualify him. I mean, it took Mr. Worrell probably about maybe 40 minutes or something like that, 30, 40 minutes. So I mean, there's no reason we couldn't do it prior to trial or prior to his testimony being offered.
Okay, I can go check with him if a report might be done and report back before the month.
Okay?
Just when you get a second, and when Ms. Rosenwasser comes back, may we approach?
Yeah.
Or Mrs. Smith? We should step up briefly.
Yeah, sure.
just didn't want to be lost in the shuffle, and I still have an outstanding one, so I just wanted to speak up as opposed to.
Your Honor, he filed that motion only a couple of days ago. As the court knows, I've been here, so I haven't had a chance to respond to it yet. I'm not sure what the
motion is it?
We're still actually, and I'm not blaming anyone here, let me just say that, but we're missing some photo lineups, and I was trying to hold off on filing it, but
That's a continuing discovery issue, so.
Well,
if you don't get it prior to trial,
well,
supplementing discovery.
I filed a motion to suppress the identification based on what the transcript indicates happened, but I don't have the actual photo lineup yet in discovery.
Well, of course, until they admit it, he could admit it, you could have that typical motion. I'm running out of time, so I have to count it.
I understand. That's fine.
Yeah, before that's admitted, we can sort of take it up.
Thank you.
Your Honor, we confirm Deputy Hall is he's on his way. He'll be here. We should be able to take him after Henniger if he's on his way. And if he's not here, I can be ready to argue this.
All right, we said as far as our issue of the 8-1,
Yes, sir. Yes,
You
sir. Yes.
Okay, all right. Okay, can we call Dr. Henninger?
Absolutely, Your Honor.
Dr. Henninger.
All right, please send Dr. Henninger. Hey, folks, McGowan, we're talking. Look, if you all could kind of keep this down a little bit because small pockets of conversation distract from where we are, so or us to be able to hear globally. So, to the extent that you need to have a conversation, keep it in low tones, or just wait until we have a break. Okay. All right, Dr. Henninger, good afternoon, sir. You approach the witness stand. Once you get there, if you would be so kind, you turn faces Lieutenant Gibson, respond to the witness, sir.
Please sit. Remain standing, sir. Raise your right hand. Do you swear or affirm that the testimony you give in this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may lower your hand. You may be seated. For the record, please state your name, spell your first and last order, and state your occupation.
Okay, my name's Dr. Michael Henniger.
Make sure you speak.
Can you hear me okay? Okay, my name's spelled M-I-C-H-A-E-L and then H-E-N-I-N-G-E-R. And I am a forensic pathologist at the Fulton County Medical Examiner's Office.
Good afternoon, Dr. Henninger. How are you?
Excellent.
Good, good. How long have you been a forensic pathologist?
I started working at Fulton County as a forensic pathologist. It's my first and my job, basically, in 1995 in July.
Okay.
So since then.
Okay. And can you tell the court a little bit about your education?
Yes. I started out at Utah State University. I received a Bachelor of Science degree in biology. And then I went to medical school at the University of Utah, and I received an MD degree. I went into the military and did an internship in internal medicine at Keesler Air Force Base in Biloxi, Mississippi. I practiced primary care medicine for a few years. After I finished my commitment to the military, I went back to Utah. I did a 4-year residency in anatomic and clinical pathology, and then I did a 1-year fellowship up in Minneapolis at the Hennepin County Medical Examiner's Office in forensic pathology. And when I finished that training, I came to Atlanta.
Great.
Began to work for Fulton County.
When did you, when did you start studying medicine?
I went to medical school I started medical school in 1982. I did pre-med undergraduate, so basically when I graduated from high school, I started doing pre-med classes. Okay. And even some of the high school classes were, like they teach physiology and biology in high school. So, I mean, I'd have to go back to the 9th grade to really say that's when I started studying things that were academically going to lead to medicine.
Thank you, sir. Are you involved in any professional organizations?
Yes, I am.
And what are those?
Okay, there's 2 of them that are that people in our field belong to. There's one called the American Academy of Forensic Sciences, It's a big, huge group of people that from all different disciplines, not just in medicine. There can be anthropologists and dentists and different areas of expertise. The one that's particularly focused on forensic pathology is called the National Association of Medical Examiners. It's a smaller group, but they're all forensic pathologists, most of them anyway. And they I also belong to the American Medical Association.
Your Honor, at this time, I'd like to move into State's Proposal Exhibit 16, I believe it is. Permission to approach the witness?
Anybody not seen State 16, Dr. Henry, you see who? You may approach.
Thank you, Your Honor. Dr. Henninger, what is that, doctor? Do you recognize that, doctor?
This is the version of my CV that I have on my desktop. That's kind of a basic summary of simple basic summary of my CV.
Has there been any alterations to that document?
No, there's, trying to see if it's, I think I had one more article that's on this, but that's just probably since I gave that to whoever did. But anyway.
Any objection to State 16? All right, State 16 is admitted.
Dr. Henninger, am I pronouncing that right?
Yeah.
Okay. Do you have any certifications?
Yes, I'm board certified in anatomic and clinical pathology. I'm also board certified in forensic pathology.
And with those certifications, are there any kind of continuing education courses?
Yes, there are.
Okay. Can you tell the court a little bit about those?
Okay, continuing education, basically, on average, once a year, we have a national meeting that we can go to, and they usually last approximately a week, and their lectures and papers are presented, and their discussions about various fields. I generally have gone to those. I've gone to more than required some years, and occasionally I do present things. I'm not an academic forensic pathologist. I'm not one of the people that are in the middle of doing that and doing the major lectures, but we attend those, and that's a requirement to maintain a license to practice medicine.
Okay. Are there any tests you regularly have to take?
Okay, they have instituted that, but when I got board certified, they hadn't, and I haven't had to take the tests. So there aren't any of that. I mean, I've helped write the test questions when they request that. I'm kind of, my level of experience, I'm more on that side of it. But.
Sure. So I want to kind of transition. How were you trained in performing autopsies?
Okay, that's a very good question. We start out, basically when I was an undergraduate in college, my last year, we had an anatomy class at the college, and we had a cadaver that we looked at. So we started learning anatomy at that point. In medical school, we had a year-long course in anatomy, and we did basically one autopsy all year long. So we went through every single thing they could think of. And then when I was a fourth-year resident, I did a rotation in pathology, and they let me kind of do an autopsy and under close supervision. So those are a few, and that's more than is typical for students today, but probably pretty typical for that time. But the real training begins in your pathology residency, where you're required to do a certain number of autopsies. So that's when I started doing autopsies, more than one, and focusing on learning how to do them. And those were hospital autopsies that are basically looking at people's natural diseases, so it's more closely related to medicine, and the forensic aspects aren't really in that. And then when I did my fellowship in Minnesota, the first day I was there, I did a forensic autopsy under supervision. The second day I had a homicide that ended up going to court, and I was under supervision doing that with really close supervision. So that's how you learn, and you do. I did about close to 200 of those that year. And then when you're in practice, you're constantly learning from your cases. You don't just walk into this knowing everything. And then there's the process where we had a fellowship and I've helped train other physicians. So that's kind of how I've learned how to do autopsies. It's a work in progress that keeps going on for your whole career.
And do you typically stay up to date with like developments in that field?
Yes.
Have you ever taught any classes?
Yes, I don't have that in my resume, and they're not that well documented, but I have taught over at Emory. They had several lectures that they have in all different kinds of areas of pathology, and I've done several lectures on forensic pathology at Emory, and they're geared towards pathology residents, not necessarily forensic pathology residents. Most of the teaching that goes on in our office, we do have little kind of one-on-one training sessions with the fellow, but a lot of it's at the what we call the bench, or at the autopsy table, where you see something interesting and you show it to the resident, or you're watching what they do and pointing out things they need to do. That's kind of guiding them through this process. So,
how often do you teach over at those classes over at Emory?
Right now, they were canceled during COVID, and then they haven't really started back up. Or if they have, they're having other people do them I don't know about.
Have you ever received any awards for your work?
I don't know, paycheck. I don't. I mean, not really. It's not. I'm not like the people who get the awards are people who are usually in administrative stage. There's, I don't know. Not really. I guess no is the answer.
Has your work ever been published?
I have been involved in writing articles. The person I worked for 20 years was one of the academic forensic pathologists. He was the head of NAME at one point, and he wrote like hundreds of articles. And he encouraged me, and I did do a few. They weren't really required, so I did. I just kind of plugged away at it. So I have on that resume, I've got a list of articles that I've either written or helped write.
Approximately how many autopsies have you done or assisted with over the years?
Well, assisted with is really interesting, but just done. I've done at least 250 for 27 years, 250 each year. So that's up over 7,000 autopsies. As far as assisted, depends on what degree, because we have meetings and we talk about the cases, and the more complicated cases we talk about more. And that would be the total caseload of our office, which is over 1,000 a year of just autopsies, and at least 2,000 cases. So those numbers get really high, but they're not. I think it would be deceitful for me to say, some big, huge tens of thousands of those.
Sure.
I mean, I was involved in the more interesting ones. Most of them are just,
Have you ever been qualified as an expert before?
Yes.
In which states?
Minnesota and Georgia.
Which courts?
Mostly Fulton County. The first couple years I was here, we worked at the GBI, and I testified. It was kind of Fulton County and GBI. We covered both areas. And I did get to testify in several murder trials in various places around Georgia, not in metro Atlanta.
And about how many, I'm sorry, let me strike that. Have you been qualified as an expert in civil cases as well?
A few.
About how many times?
I haven't kept track, but it's not a lot.
If you can recall, what was the nature of that testimony in those civil cases?
The civil cases I've been involved were usually depositions, and they're usually related to injuries and either traffic accidents or on the job injuries, things like that. That basically they wanted to know the injuries and the cause of death. But I mean, certainly wasn't testifying about all the other things that go into that.
Okay. Dr. Henninger, what techniques do you use to conduct autopsies and determine cause of death?
Okay, so there's the autopsy itself, which is like a medical procedure where we examine the body in a systematic way. We have investigators that are similar to, some of them have been police detectives or they're similar to them, but they collect information and we evaluate that information. And then we have tests that we do, lab tests basically. There's toxicology, there can be other lab tests. We have an x-rays that we look at and take. So those are some of the things that we do. And then I guess the other half of that is documentation, and we take pictures and we create a report.
How did you learn these techniques?
By doing them, basically. Yeah, the autopsy itself, I mean, started way back, the beginning, and then the majority of that is exactly how to do them efficiently, how to do them with chain of custody issues in mind, forensic issues in mind. That happens in my fellowship. And so basically I'm doing a case, but a person that's experienced is standing right there, and they let you go as far as you can. And part of being on the other end of that is, is knowing how to step back and look at a fellow who's training and let them go just far enough that if they make little mistakes, they're not serious, and kind of stop them before they cause problems, but not let them get, into where they do really major mistakes.
Do others use those same techniques?
Yes. I mean, my experience isn't great, but from what I can tell from the meetings and from, different talking to people, it's fairly homogeneous across the different offices. There are probably minor details that are different in different places that I'm not very familiar with, but I think that's pretty much the standard way.
Okay. And how would you go about determining the cause of death?
Well, the same thing. I want to look at the information, the circumstances. I want to look at the autopsy, if I did it, or else to read the report and look at the pictures if I didn't. I want to see all the ancillary information and then, think about it. I may even look stuff up. I have textbooks, or else, get online and find reliable sources for answering questions I may not have on the top of my head or whatever, and then make a determination of cause and manner of death.
Do other medical examiners use those same techniques?
As far as I know, all the ones that I'm acquainted with use something very similar to that.
Okay. And do you know, are these procedures published in a book, a textbook?
There's several textbooks that have different aspects of it. I don't know that we have one comprehensive textbook that tells everything you need to know for everything. There's books, a lot of textbooks are just information like say you might have a chapter on gunshot wounds, it'll tell you about gunshot wounds. And then there are books on procedures, on, how to do basic procedures. And then there are also like uncommon procedure, unusual procedures. And then when you've done it a lot, you can often kind of see where the boundaries are, and you can create like other approaches that are within the realm that can answer questions.
Sure. What about professional publications? Have those procedures been published in professional publications?
Some of them are published. There's books that have been published systematically by people who are familiar with a lot of different procedures, and then a lot of the articles are like kind of interesting, unusual situation where they had to do something different than usual. So there are books that do that.
And typically, how would you stay up to date with the procedures?
Basically, I go to the meetings and talk to people. Until COVID hit pretty hard, I rode the train to work every day. I had 2 hours to read. I just mostly read forensic pathology or general pathology textbooks because, that seemed like it's part of my job. I'm sitting there, I'm going to work, it's hard. I might as well read that instead of something else,
Dr. Henninger, is your work ever checked by your colleagues?
Yes.
Okay. Do you check others' work?
Yes.
How often?
All the homicides are reviewed, and then the other reports are we have a morning meeting where we present the cases and decide what we're going to do, And then at the end of that, we go over the cases from the previous day and to kind of see, basically it's teaching for the fellows and the residents that are there. But it can also, it functions as people can see what everybody else is doing. You can kind of learn. And often people will raise questions, they'll find something, they'll say, well, I wonder what this means, or what is this? So that.
Are there standards that basically control your assessments and your work?
Yes.
Are there best practices?
There are best practices is fairly nebulous because if you're really good, you may do better than someone else. But there are definitely standards, and the standards try to describe what is good practice, for sure.
And do you follow those best practices?
Yes.
Who else would you say use the same procedures as you?
Who else uses the same?
Who else would you say use the same procedures as you?
All the people on these reports were using them, and let's see, 2 of them have moved to other offices. As far as I know, they're still doing things similarly.
Do all federal, state, and governmental agencies performing autopsies use those same procedures?
I don't know about the federal government. I think they do. They're mostly military people. They may have their own things, but the states, all the states, there's state medical examiner systems, their counties, and I think all those offices are following very similar to our procedures, or at least attempting to.
And did you perform, in this case, an autopsy of a Donovan Thomas Jr.?
Yes.
And did you follow all the standard and procedures that you discussed above?
Yes.
Your Honor, at this time, we would ask the court to qualify Dr. Henninger as an expert in forensic pathology based on his number of years of experience, his background, his training, and the fact that this is well-established, accepted field in forensic science.
All right, anybody else to the Okay, then the court will designate Dr. Henninger as an expert in the area of forensic pathology. May Dr. Henderson be permanently or temporarily excused for the purpose of the motion? Yes, sir. All right. Dr. Henderson, appreciate you coming to visit us.
Thank you.
Good to see you. Just don't discuss the testimony anybody except the attorneys in this case. We'll call you when we need you. Okay?
Okay.
Thank you, sir.
Thank you.
Okay, so did you, Mr. Jordan Watson, did you talk with Mr. Bernini?
He is. We sent him back on his way. He said he's going to try to have a draft report basically as soon as he can, hopefully before the end of the year, and he'll definitely have a final report before trial. We'll turn it over as soon as we have it.
Okay, all right. And we'll hold off on him for the time being. Consistent with his completing report before he testifies, or you decide to present the witness in this case. We'll go through a job of analysis of threshold requirements. All right. Okay, so the only person you have this afternoon is
Deputy Hall, Investigator Hall. He is. He said he should be here momentarily. I can give him a call and get you contact ETA. Oh, or we can go ahead and I'm ready to do Farley's motions as well. Sorry.
Let's go ahead. Your colleague and Ms. Smith will go ahead and check on him. And we'll go ahead and let you continue with Farley's motion. Part about I think you're going to talk about the duplicative accounts and
the gang constitution.
the duplicative accounts and the gang statute and Have you put Mr. Carlson on already to potentially talk about 14?
He can do it, or I can do it, Your Honor. So either one of us, I'll let him know, but I can also do it myself.
You might want to let him know. Mr. Smith, you'll check on Mr. Carlson and his availability as well as you can check on Mr. Bernini's arrival. We'll go ahead and start off with the other. Okay? All right, so, Mr. Farley, if you want to, Mr. Menez, if you want to go ahead and you have any argument as to the duplicative counts?
Yes, Your Honor.
All right, go right ahead.
All right. Good afternoon, Your Honor. I mainly rely on Meeks v. State, which is 309 Georgia App 855. That held that a one count of theft by taking was subject to a special demurrer because it was entirely duplicative of another charge that was charged in the same offense. And here, Your Honor, I'm basically asking the court to apply Meeks to this indictment the way it's specifically written. In Meeks, the Georgia Court of Appeals held that the counts were duplicative because they provided no additional facts by which it can be distinguished from the other count, and it alleges neither a different set of facts nor a different date. And so, Your Honor, that's what I allege, that counts 50 and 51 are duplicative of count 49. Count 49 is where Mr. Farley is alleged, along with Mr. Stillwell, Nichols, and Garlington, to have murdered Mr. Drinks. And in that count, they say, the reason why, Your Honor, this is especially duplicative is it says that Mr. Drinks was an associate of a rival gang. So essentially what I'm asking the court here is to find it duplicative, because I know the state's going to say that a gang activity charge and a murder charge are not duplicative, even if it's that murder that is the basis of the gang charge. But, Your Honor, I think that this can't survive a demurrer under Meeks because they write up count 49 as a gang charge. They just don't write the caption. And, Your Honor, the caption is not what holds, it's the substance. And so here in count 49, the substance is the same as counts 50 and 51. Had they not put in that part where it says an associate of a rival gang, then I get it. There's an extra set of facts that, oh, we're saying you killed this guy, and then in this other count, we're saying you killed him as part of gang activity. But 49 says an associate of a rival gang. So because they wrote that in there, and they didn't have to, that's not part of the malice murder statute by any means, but they chose to allege it that way. And so within the four corners of this indictment, of which Mr. Farley is entitled to an indictment perfect in substance and form, here it's duplicative. Had they not put that, it wouldn't be duplicative. But what I submit to the state, what different fact is alleged in counts 50 and 51 that's not alleged in count 49? Because in count 49, they say it's an associate of a rival gang. So if you say someone has an associate in a rival gang, by inference, you're saying that that person is in a gang. And essentially, count 49 alleges Mr. Farley to be in a gang, and it alleges that the person killed was a rival of the gang that Mr. Farley is supposedly in. So count 50 and count 51 that allege the criminal street gang activity with the murder of Mr. Drinks as the subject matter, Your Honor, those are both duplicative of count 49 because they included count 49 as gang activity. So looking within the four corners of the substance of these three counts, there's nothing different in count 51 or 50 that we don't already have in count 49.
That it?
For that motion, yes, Judge.
Okay, talk to me about the unconstitutionality of the gang statute.
Sure, Judge. So,
And you understand the Supreme Court already considered that issue, right?
I understand, Your Honor. I don't think the Supreme Court's going to consider anything with regards to Mr. Farley because there won't be a conviction. But just out of caution, I do think maybe the United States Supreme Court or possibly some other court might review this, Judge. So I do...
I'm just
Right.
giving what's your good faith basis to challenge.
Yeah, I can explain that, Judge. The good faith basis is that Rule 418 in combination with the Georgia gang statute just completely flies in the face of the most fundamental aspect of our government, which is checks and balances between the three branches. You know, we have Your Honor representing the judicial branch, we have the state representing the executive branch, and we have myself and the other attorneys representing individuals and people in the state of Georgia. And so how it's supposed to work is that we're supposed to be checking each other, we're supposed to be balancing each other. But what we have here is, Your Honor, Rule 418 just completely circumventing Rule 404B and rendering 404B meaningless and robbing both the people of the state of Georgia and the judicial branches of the state of Georgia of any sort of check on the authority of the state to circumvent the legislature, who's elected by the people of Georgia to write the statutes, who wrote 404B. And Your Honor, under 404B, as the court knows, other acts are not allowed in for propensity. They're only allowed in for limited purposes like intent, motive, absence of mistake.
Wouldn't you agree that it's a different statute promulgated for a different reason?
Exactly, Judge. And what's the huge problem here is that our grand jury proceedings are entirely secret. They're not transcribed, and there is no mechanism for either the people of Georgia or the jurists of Georgia to check the state to stop them from doing what this leaves open to be done. So, for example, which is, Your Honor, they might in bad faith, let's say we have a murder case, and that person accused of murder has an aggravated assault, but there is no other way to introduce that except for propensity. So the judge would say, as the state would know, that, you know, I'm denying your 404B, this is propensity, that's not allowed. Our legislature does not allow propensity. However, 418 does allow propensity. And that's what makes the gang statute and rule in combination with Rule 418 so unconstitutional under the United States Constitution. Because what's to stop the state in a secret, untranscribed grand jury proceeding in bad faith just throw on a gang charge onto the murder charge, then... Right, Your Honor, but there's no one to check them. They're doing it in secret, and it's untranscribed, so there's no one to hold them accountable. We have rules, but without enforcement and accountability, the rule is meaningless. And so 418, in combination with the Georgia gang statute, has made 404B meaningless because all they have to do is throw a gang charge on there in violation of the rules of ethics, which happens from time to time, and they can choose to violate that behind closed doors, untranscribed, and then they can throw up their hands at the end of the trial and say, oh, the directed verdict got granted, we didn't know that was going to happen, wink, wink, but they did know. And the reason they did it and put it on there, even though they knew it would be dismissed by directed verdict, is that so then they can use 418 instead of 404B and then bring in, for example, a past aggravated assault for propensity, which is exactly what the legislature didn't want the state to ever be allowed to do. And so there is no... Right, Your Honor, but if we didn't have the gang statute, then we couldn't accuse someone of gang activity, and then we couldn't apply 418. We would have to apply 404B, and we wouldn't be talking about propensity. But
Evidence of the court that you know under law.
Judge, I can't hear you in the back.
So you understand that evidence under our evidence code, Title 24, may be used sometimes for differing purposes, right? So, right?
Yes, Judge.
So under the gang statute in 418, it's a little different than 404B and the other purposes for which evidence is admitted, right?
Yes.
Okay, all right.
And that's just exactly, it is the existence of that, Your Honor, that I find to be just totally unconstitutional because now there is no way to do checks and balances. It's just whatever the state wants.
The legislature wrote the gang, or enacted the gang statute and they enacted 418, right?
Yes.
So they obviously had knowledge of 404B, correct?
Yes.
All right. So, I understand your argument. Is there anything else you want to put forth?
No, Judge. Just,
okay.
I just ask you to grant that, and then the state can appeal something for once instead of us, appealing everything.
Okay. All right. Ms. Rosenwasser? Any other motions? I think I've dealt with the other. Only one is the 418, and I'm waiting on Mr. Carlson.
Yes, Judge. The only other thing I have that I failed to mention is I did have an amended discovery motion that the state's mostly accommodated, but there's one aspect they're not accommodating, that I'd like the court to
What is that?
compel them. They relatively recently, sent out these gang profiles on each of the defendants, and then nowhere in the discovery does it say who wrote those profiles and when they were written. And their written response to my motion says, well, you can just call the law enforcement witnesses. But that's exactly why I need Your Honor to compel them to tell me which law enforcement witness produced which gang profiles and when, because even though the state might try to say that's not exculpatory, the discovery statute says it's not only exculpatory things that they have to give us, but anything that might lead to something exculpatory. So the way they've described this gang profile of Mr. Farley, I think they wrote that up after this case already started, and if that's the case, that definitely impacts, my absolute theory of innocence.
Have you had any conversations with Ms. Rosenwasser or Mr. Smith or anybody else in regards to this issue?
No, Judge, only just through our written responses to the
And
motion.
why don't you have a conversation with her about that? Madam, is it that are you all willing to, or can you give him that particular information?
Your Honor, I don't want to speak out of turn. If I would just request Mr. Farley contact the trial team. I would request Mr. Farley contact the trial team leader to get an answer on that. I do not want to speak out of turn, at least without confirming with them. If he'd come up to me about this earlier, I could have relayed that message and received an answer.
Okay. So why don't you have a conversation with Ms. Love or Ms. Hilton? And then if it continues to be an issue, I'll certainly deal with that, okay?
Yes, Judge.
Hold on, we got Mr. Carlson here who can talk about 418. Do you want to go ahead and finish your 418 argument, sir, and then I can let Mr. Carlson respond to that?
No, Your Honor. Just to perfect the record, I also challenged the gang statute for violating freedom of speech and freedom of association, but I don't have further argument about that. I just have it in my motion. Everything I object to about 418, I've already said to the court.
All right, Mr. Johnson?
Yes, Your Honor. On behalf of Mr. Eppinger, I wanted to join in Mr. Menendez's motion.
David, if you ever listen to Mr. Harvey, I hate to cite to him all the time. I hate to cite to him all the time. But he did you all such a solid. He said, look, unless you opt out, everybody else gets to opt in, right?
Well, yes, Your Honor.
Okay, so add to it.
I'm going to add it specifically as it relates to Mr. Eppinger.
Okay, so let's take care of that.
Yes, Your Honor.
But if you start replicating, I'm going to cut you off, all right?
Your Honor, the court is aware of Mr. Menendez's arguments.
Just heard it.
Just like to
And
say,
read the motion.
Yes, Your Honor. As it
Okay.
relates to my client, Mr. Eppinger, we would contend that I believe it's counts. Let me find the exact one, Your Honor. I believe it's counts 38 and 39 of, no, I'm sorry, 28 and 29 of this matter, which charged my client with possession of a firearm by a first offender. The two counts are exactly written the exact same. They did not allege any different information whatsoever. And this counts 34 and 35, Your Honor. They allege that my client was in possession of a firearm on a particular date after having been convicted, placed on first offender for a particular crime. It is the same crime, the same date as listed in counts 34 and 35. There is no additional information required or added in this that would differentiate these two counts, Your Honor. So based on the similar arguments made before, we do believe that these counts are duplicative and should not be included in the indictment, Your Honor. Well, at least one of them should not. Thank you.
That it?
Yes, that's it, Your Honor.
Okay, all right. All right, Mr. Carlson, can you speak to Mr. Menendez and by implication the rest of the defendants who have specifically decided to opt out are seeking to or have this court declare Georgia Rule of Evidence 418 unconstitutional. So if you would speak to that, I would appreciate it.
May it please the court, Your Honor?
Go ahead.
And if I may, Judge, approach the court reporter with my car.
You may.
Thank you. Your Honor, again, Mike Carlson, Executive District Attorney on behalf of the state, responding to the constitutional challenge. I believe it's actually to 1615-4, the charging provision of Georgia's Street Gang Terrorism and Prevention Act, as well as Official Code of Georgia 24-4-418, which is an evidence code provision that exclusively applies to cases charged under OCGA 1615-4, and that is by language of the statute. So, Your Honor, let's take a look first what we have here. These are essentially facial challenges to both of these statutes before the court. There's no acknowledgement in the briefing that at least has been reviewed by this Assistant District Attorney of the controlling or persuasive authority involved. And that begins with the fact of a presumption that a Georgia statute is constitutional, presumption that the challengers, the court knows, must rebut in cases like State versus Brannan, B-R-A-N-N-A-N, 267 Georgia 315, 267 Georgia 315, that's a 1996 case, sets forth. Also, in a facial challenge such as this, the opponents have to demonstrate that there is no set of facts under which the Gang Act or 1615-4 would be valid. A case for that out of the 11th Circuit is Benning versus Georgia, 391 Fed 3rd, 1299. 391 Fed 3rd, 1299, that's an 11th Circuit case from 2004. So accordingly, these challenges should be denied and the motion should be denied. Now let's take a look first at the challenge, which, and again, my apologies for not being here for all of the argument, but based on what I did hear and based on the briefing, is a First Amendment challenge. Well, that was dispensed with, Your Honor, by our Supreme Court in a 2009 decision, Rodriguez versus State. 284 Georgia 803, 284 Georgia 803. Now, Rodriguez was strictly a case under OCGA 1615-4A, that's Alpha Judge, the primary charging provision of the Street Gang Act. But notably in Rodriguez, the court explained, and the late Justice's opinion affirming Judge Hancock of DeKalb County's decision pointed out that the gang statute prosecutes conduct, not association and not expression. And I'll read a quote from the case. Criminal gang activity, quote, is not protected activity even when committed by a group exercising their constitutional right of free association, because, of course, there is no constitutional right to commit criminal gang activity. And when that criminal gang activity is committed by an individual who is a member or an associate of a criminal street gang and participates in the gang through the commission of that criminal gang activity, then the additional offense of a violation of 1615-4A can be brought. Now, there is a complaint here about 1615-4B. That is the commission of those offenses in order to increase or maintain status in the gang. Again, that is criminalizing behavior, not expression. So, as to the double jeopardy claim that we saw there, at the outset, let's direct the court and the record and opposing counsel to OCGA 16-15-4M as in Mary. That is a statutory non-merger provision that is housed within the Street Gang Act itself. And our Supreme Court and our Court of Appeals have specifically dealt with the issue of whether or not someone being charged with multiple subsections of the Street Gang Act and being sentenced and convicted, or convicted and sentenced for those subsections as well as the predicate offense, violates the Constitution. No merger, no violation in that case, Judge. And I want to take us first to the Court of Appeals case on that, Judge, which is Nolly versus the state, wherein the specific quote is that in Nolly, let me actually, before I get to the quote, the defendant was charged with more subsections than any of the defendants here were. And that was actually, there was an A, B, D, and E violation in addition to the underlying predicate, and the courts there said in Nolly from the Court of Appeals, and I'll have that citation to you in a second, Your Honor, from my co-counsel, there was no violation of merger or double jeopardy rules. Lupo versus State from the Supreme Court, 300 Georgia 233. That's a 2016 case. The gang activity counts did not merge, as that crime and malice murder each require a proof element that the other does not. And of course, that's consistent with federal and other state and Georgia RICO authority as well, Your Honor, which I'm happy to provide. Then there was Anthony versus State, again. This is at 303 Georgia 399. We previously had rejected the idea that all gang offenses must be gathered into a single gang activity charge. So the subsections of the Street Gang Terrorism and Prevention Act all have different elements. Those elements are different than the predicate offenses, so they all can be charged, convicted, and sentenced separately. And in fact, there is a statutory non-merger provision within the act itself. So, Your Honor, the constitutional claims fail in terms of 1615-4. So now let's look at a later enacted statute, 24-4-418. Now this is a provision that is unique to Georgia and only applies to cases that are charged under Georgia's Street Gang Terrorism and Prevention Act. And it's patterned after, Judge, the same evidence code provisions that apply in sexual offenses and lawsuits arising from acts of sexual misconduct. Georgia has those at 24-4-413, 14, and 15. They're in the federal rules of evidence under the same numbers, and I believe, Your Honor, they're also in the military rules of evidence under the same numbers. So the question is, does the admission of character evidence somehow in and of itself violate the Constitution? There's been no case law provided to that effect by the opposite side, and while the U.S. Supreme Court, I believe, has yet to definitively answer that question, there is certainly no controlling case law to say that these statutes, which are used and approved around the country, somehow violate the Constitution. So we ask a question, is there a due process problem here? Well, Rule 403 applies, Your Honor, and although it is a presumptive admissibility statute, that does indeed allow other acts that qualify as criminal gang activity to be admitted for any purpose, including criminal propensity. Those parallel the rules that apply in sex offenses, in federal courts and in Georgia courts, and quite frankly in other states, California, for example, Your Honor, there are similar rules that apply in elder abuse cases, special needs abuse cases, domestic violence cases, as well as in non-sexual child abuse cases. Those have been upheld, and you'll see in our brief we've provided you with jurisdiction after jurisdiction after jurisdiction where rules that parallel this one, in fact, have been upheld constitutionally by federal and state courts around the country. An additional case on that, Your Honor, State versus Gee, G-E-E, that is at 388 Wisconsin 2nd, 68. 388 Wisconsin 2nd, 68, a 2019 case, and where they say, they quote the United States Supreme Court of Dowling versus U.S. 493 U.S. 342, 493 U.S. 342 at 1990, whether the introduction of this kind of evidence is so extremely unfair that its admission violates fundamental concepts of justice. Well, Your Honor, this type of evidence, even without the gang statute involved, even without 418, is generally admissible. The rules of intrinsic evidence are relaxed, generally speaking, when it comes to racketeering cases federally, and of course, in sexual offenses, even without a 413 or a 414, those were more easily admitted under our former evidence code. And just to go to a military case on that, Judge, U.S. versus McDonald, 53 Military Justice 593, 53 Military Justice 593. Again, a direct attack there on 413 and 14 on due process grounds, and just stating that a review of the pertinent appellate decisions indicates the courts have uniformly held that such constitutional concerns are satisfied by the proper application of the Rule 403 balancing test. So is this a statute that allows other acts in presumptively? Yes. Does it allow it in for all relevant purposes? Yes. But that was the design of the statute, In fact, it's right there in the enabling language of the statute in the preamble, quote, to improve the ability to prosecute street gang terrorism and provide for the admissibility of similar transaction evidence in prosecutions for criminal street activity. And that, of course, corresponds directly with the purposes of the Street Gang Act under OCGA 1615-2 to eradicate that kind of crime. And those are the words of our General Assembly as part of and a response to a state of crisis. So the constitutional challenge to 418 fails. 418 applies. There's not a due process consideration here because, again, the statute is tailored to these considerations, and certainly criminal street gang members committing criminal street gang acts are not a protected class that would raise equal protection concerns. So now we go to this last issue of, so the constitutional challenge to 418 fails on its face. So now we get to the issue of whether or not the other acts evidence, the uncharged misconduct to be admitted under Rule 418 requires a prior conviction under 1615-4. That issue was just argued in front of the Georgia Court of Appeals successfully by Assistant District Attorney Rosenwasser in the case of State versus McKinney. I've got the Lexis site for that, 2022 Georgia Appeals Lexis 545, 2022 Appeals Lexis 545, where the Court of Appeals noted that the language of Rule 418 itself does not require a nexus in terms of the other acts evidence to be brought in between the gang, the crime, and the defendant. Only that the prior offense, the other acts, could be subsequent classify under 1615-3. So for any evidence the state is going to proffer under 24-4-418, if that offense qualifies as criminal gang activity under 1615-3, it thus becomes presumptively admissible for all relevant purposes under the plain language of 24-4-418. So, Your Honor, with regard to the facial constitutional challenges, we request that the court deny those respectfully. With of course, to the specific challenges to 1615-4 and 418 constitutionally, we ask that those be denied, and we also ask that that the court deny now and apply prospectively during the trial of this case 418 properly and reject any argument that the other acts have to have constituted a convictable offense for 1615-4. Thank you, Judge.
Okay.
And Your Honor, none of that addressed any of my arguments about unfairness. It just cited to Georgia statutes and then conceded that 418 is unique to Georgia, which is why I'm challenging it so that it can be reviewed by a higher court. Because if you don't challenge anything, Your Honor, in this system of a living constitution, nothing can change. And there have been plenty of times in our history, and even recently with the Dobbs case, that there's just things have changed and courts find something to be unconstitutional. Here...
Well, you've made a constitutional challenge. I mean,
right, Your Honor.
So if and when this case is reviewed, our Supreme Court will consider those particular issues.
Yes, Judge. And I just real quick to perfect the record want to address a couple of things. He said, the state said I didn't address any actual authority, but I did. In the very first paragraph of the motion, I say that this is a violation of the 5th, 6th, and 14th Amendments of the United States Constitution. It allows propensity, whereas 404B doesn't, without any rational basis. Under the 14th Amendment, for there to be any kind of discrimination, there has to be a rational basis. The basis the state articulated is to eradicate crime. But what is the rational basis that gang activity is more important to eradicate than murder or rape or child molestation? So why should an accused rapist not have propensity in his trial, but an accused rapist where the rape was part of gang activity that the state knew couldn't survive a directed verdict, now we got to eradicate that? That's what's not fair, Your Honor. There's no rational basis here under the 14th Amendment. It's unique to Georgia, and I don't think the state even said this hasn't been challenged. This hasn't been addressed exactly by the United States Supreme Court, and so under all that, Your Honor, I do want to challenge it and get a ruling for this court to preserve that issue for appeal.
All right, Mr. Carlson, you want to address the issue of whether or not this is or rational basis and the correct constitutional standard?
Certainly, Your Honor. This is the parallel provisions federally that apply in sex crime cases have been on the books since, I believe, 1996. There has not been one successful constitutional challenge to any of them cited by the defense. And, of course, the state has provided the court with just to the contrary. In terms of whether or not there's a rational basis here, the legislature in the preamble to the Georgia Street Gang Terrorism and Prevention Act, let me change that. In the preliminary language of it, in OCGA 1615-4, talks about the state being in a state of crisis due to criminal street gang activity, violence to include murder. So the General Assembly looked at that situation and enacting the gang statute, and of course continued to strengthen those laws in the face of that state of crisis. Again, that's our General Assembly's terms, all the way up into drafting 244418. And I would point out, Your Honor, that this is one of 4 specialty evidence code provisions that particularly applies in Street Gang Act cases. There's 1511-703, 15-11-703, which provides for the admission of juvenile adjudications in cases prosecuted under the Street Gang Act. There is 16-15-3, which is housed within the Street Gang Act, which allows in evidence of the customs and behaviors and symbols of gangs, among other matters. And then there's OCGA 16-15-9, which allows for the admission of other criminal gang activity of the gang. So there is certainly a surrounding statutory body that demonstrates the importance to our General Assembly, which is the fact finder here, that having specialized statute to facilitate the admission of street gang activity, whether by an individual defendant or whether by the gang itself, is clearly something that is necessary for public safety. Just like in the case of the sexual offense provisions, or the evidence code provisions that connect with sexual offenses, that those needs to allow in other acts at a different level than would be allowed under 404B would be. So these are legislative determinations. Again, we're not talking about a suspect class here in the constitutional sense under equal protection, and due process is satisfied because Rule 403 applies, and the Court of Appeals was absolutely clear about that in the McKinney decision. So again, we don't have a recognition of Rodriguez in terms of 1615-4 by the defense in this case. We don't have an acknowledgement of any of these cases pertaining to similar statutes from around the country or federally. And again, we have a constitutional statute that was enacted by the General Assembly to deal with the state of crisis of gang activity.
Okay.
Thank you.
Thank you, Mr. Conley.
Very, very briefly, I don't think that argument about...
Don't get back to the podium. Stay right there. Stay right there.
Yes, Your Honor, that argument
All
about
right.
403 just doesn't hold up because of the propensity difference. For example, 403, we're balancing probative...
But it's a specialized statute that the legislature enacted for purposes of this particular issue. So I've heard your argument. Is there anything else you want to add?
Yes, just to add that under 404B, propensity is not allowed, so propensity is not probative. But under 418...
Well, that's the no. It's the test after you look at whether or not 418 still requires 403 to be applied. I mean, so that's your check and balance. And the recent case that Mr. Carlson just cited in State versus Kinney, that was in the Lexus site 22 Lexus 545. That's what our Court of Appeals has determined in that respect.
Well, yes, Judge.
So you disagree, though?
Yes, we can.
Okay. All right.
That's okay, Your Honor. What I do want to say, though, is that because propensity is allowed under 418, we only say that as if they're now giving probative value to propensity and allowing 403 to consider propensity as probative value, which allows it to outweigh prejudice in a way that it shouldn't.
No, it doesn't outweigh prejudice because you still have to balance it under 403.
Yes, Judge.
I mean, look, all good. I mean, the argument in a number of cases is, oh, this is prejudicial. Well, good evidence certainly is prejudicial under a lot of times, under a lot of circumstances. However, 403 being a balancing test requires the court to not just look the other way, hold its nose, but I still have to make sure that the balancing test under 403 has been met. So
There's your safeguard.
Yes, Judge, I just think that the balance turns out differently if you consider propensity, whereas if you don't in certain cases. But I understand that the court and I can disagree. And just lastly, for the record, I don't think at all that being in a state of crisis is a rational basis to survey due process rights.
Well, here's the thing with as you well learned in law school, right? There's 3 levels of constitutional scrutiny: rational basis, intermediary scrutiny, and strict scrutiny. And that for public safety, the bar's pretty low. I mean, as a general rule, and that the states or governing bodies are free to, that's the one that usually they win on most of the time is for safety of the public. So if that's what the statute was indicated or was enacted to deal with, and if you look at the preamble when they did it, it does say, we're in a state of crisis in terms of crime and other things, and that was the basis for them to enact the statute. So, good luck on that. But okay, but look, I can't say enough that you're not representing your client, you're representing him well. And you preserved it for appeal, so you've done your job, okay?
The very last argument I want to preserve for appeal is that the reason I don't find that to be a rational response to crisis is because there's so many other ways that's rational to respond. For example, fixing the school system or defects or all these other things that you can actually address the crisis instead of stripping away our due process.
Okay, well, I'm sure that you'll argue that very well to our Supreme Court, okay? If and when it's taken up, all right? Anybody else? I saw some other people may want to get up. Mr. Hoover or anybody else before I rule? Okay, I know all of you adopt Mr. Menezes' motion and his argument. Okay, all right. Ms. Rosenwasser, let me let you finish before I go ahead and rule. I think that you were going to talk with me a little bit about the issue of the duplicative counts as well as the constitutionality of the Georgia gang statute. Is that correct? Yes. And I think that will conclude, at least for the time being, Mr. Menezes' motions until such time as we're able to hear those particular other witnesses, the witnesses that will require motions that will require witnesses, I should say.
Yes, Your Honor. So first, as to the duplicative counts, if I understood Mr. Farley's written motion correctly, it was a little different than what we heard today, but I'm happy to respond to all of it. So first of all, in his written motion, it seemed as though he was complaining that counts the indictment, later in the indictment, 50 and 51, mirrored some of the acts under count 1. So to respond to that first, Your Honor, first of all, as to count 1 acts 173 and 176, those are acts under the RICO count. They are not separate counts. So what's really going to drive us both through this conversation and through the addressing of what Mr. Farley talked about today, where he alleged that murder and criminal gang activity are duplicative of one another, there's some language that guides us through that. And what I cited to in my brief is the language out of Williams versus State, which is a 2020 Georgia Supreme Court case. It's in my brief, but if the court wants to cite, it's 307 Georgia Supreme Court 778. And in that case, the court said, the United States Supreme Court observed that a draftsman of an indictment may charge crime in a variety of forms and may cast the indictment in several counts, whether the body of facts upon which the indictment is based give rise only to one criminal offense or to more than one. Further, by an indictment of multiple counts, the prosecutor gives the necessary notice and does not do the less so because at the conclusion of the state's case, the defendant may insist that all counts are merely variants of a single offense. Here, the state was properly permitted to charge Farley's act of committing a gang murder, a gang-motivated murder, in numerous ways. The state was permitted to charge Farley with participating in the RICO conspiracy from the YSL criminal street gang, and the state was entitled to allege acts that were in furtherance of that criminal conspiracy, as alleged in count 1. In count 49, 50, and 51, the state was entitled to separately charge Farley for the act of murdering Mr. Drinks and for participation in criminal street gang activity.
Which counts are those again? You said count 1?
My understanding is that Mr. Farley was challenging count 1, acts 173 and 176.
Okay.
And then also counts 49, 50, and 51. 173 and 176, acts, count 1 acts 173 and 176 are Farley and his co-defendants' acts of murdering Mr. Drinks and participating in criminal street gang activity through that murder. And those acts are alleged as acts in furtherance of the YSL RICO conspiracy. And then additionally, Farley is separately charged in counts 49, 50, and 51 with the murder and participation in criminal street gang activity with the actual, those are the charges. So the charges that he's facing relevant to this count are that RICO charge, the murder charge, and the 2 gang charges. And the gang charges are alleged under separate code sections, separate divisions of the gang statute. So basically, these counts are not all the same, so this court should deny Farley's demur. And when I looked at this, what I believe is that this is a situation that should be analyzed similar to when a defendant complains of a double jeopardy violation. And I believe that this court should adopt that framework to analyze this challenge. The double jeopardy framework is that a single offense may be an offense against 2 statutes, and if each statute requires proof of an additional fact which the other does not, an acquittal or conviction under either statute does not exempt the defendant from prosecution and punishment under the other. So I think to look here whether these counts are duplicative, it is whether it's similar to if we're looking at a double jeopardy or merger analysis. And here, these counts, none of these counts are the same. Count 1, count 49, count 50 or 51. Each of these counts requires the state to prove different elements. Simply because the state added language to certain counts stating that the victim about his gang status or gang affiliation, that does not mean that the counts are duplicative. It simply is different ways of alleging the act of committing a gang-motivated murder. These counts have different charging elements, and what's important is you look at the elements of each count. So Farley is charged in count 1 with RICO. Murder is not an essential, killing someone is not necessary to prove a RICO conspiracy violation. Same thing with participation in criminal street gang activity. Committing murder, killing someone, is not necessary to prove that someone violated the Criminal Street Gang Act. They could also be convicted of that and of murder, but it's not a situation where that's going to be a duplicative count. Those are different acts. And acts is probably the wrong word due to the RICO. Those are different actions taken by the defendant. They're differently charged, and that's completely appropriate pursuant to the Georgia Supreme Court, which quoted the United States Supreme Court. The United States Supreme Court case is United States versus Universal CIT Credit Corp. 344 United States 218, 1952. So here, Your Honor, the counts are not duplicative. They each require different elements. The state must prove different elements to show each conviction. Your Honor, these counts are in no way duplicative. Mr. Farley's demur should be denied.
Okay. Turn to the issue of the constitutionality of the gang statute, Georgia gang statute.
Yes, Your Honor. So turning to that directly, I think it's pretty clear that this has already been challenged in the Georgia Supreme Court within the last 15 years. That was in Rodriguez versus State, and in that case, the Supreme Court of Georgia unanimously held that the primary charging provision of Georgia's anti-gang laws, OCGA 1615-4, is constitutional. Farley has not shown why this court should not follow the ruling of Rodriguez or even attempted to distinguish Rodriguez. So therefore, Your Honor, we believe that it's already been ruled upon. This is a challenge that has already been made. This statute is constitutional. And, Your Honor, going into the challenges to each of these, to the extent that Farley makes a First Amendment challenge, Rodriguez versus State held that criminal gang activity is not protected activity even when committed by a group exercising their constitutional right to free association. So that's already been held. Again, I think Mr. Carlson went into this as well, but To the extent he didn't, or the court has further questions, additionally, Anthony versus State, loop specifically, and that's 303 Georgia Supreme Court 399, that's a 2018 case. The Georgia Supreme Court specifically rejected the idea that all gang offenses must be gathered into a single gang activity charge. In Lupo versus State 300 Georgia Supreme Court 233, that's a 2016 case, they found that an individual can be charged with separate violations for each of the gang statutes. So that's not a reason to find it unconstitutional. And generally, Your Honor, it's just been clear that this has already been challenged and been rejected, and Farley has not shown why this court should not follow pre-established case law. And Your Honor, I do want to provide the court additionally with the Nolly site that Mr. Carlson referenced. That's 335 Georgia Court of Appeals 539, 2016, and that actually goes in support of both his case and his argument and my argument.
Okay.
Okay. Okay, councils, appreciate you all giving me some time to collect my thoughts on this particular issues. As it pertains to Farley's motion in regards to amended and special demurrer 7, duplicative counts, this court has considered that Farley is charged in count 1, acts 173 and 176, and counts 49, 50, and 51. And applying, as was mentioned, Williams 307, Georgia 778, these counts are not all the same, where they require different elements of proof, and Farley's motion on that particular issue is denied. As it pertains to the constitutionality of the gang statute, which is 1615-4, this court has considered the council's arguments, in particular Rodriguez versus the state, which is a seminal case dealing with the constitutionality of this particular statute at 284 Georgia 803. The proponent, Mr. Farley, has not shown how Rodriguez is not constitutional. It's not. This particular statute deals with. It doesn't protect activity as authorized by the First Amendment in terms of freedom of association. So it's not a protected activity. So criminality and the prosecution thereof of that is different than the issues under the First Amendment in terms of freedom of association as authorized or guaranteed to us by the First Amendment. So Farley's motion on that issue fails as well. In terms of the motion to declare 1615-4
24-4-418, admissibility of gang activity. I agree with Mr. Carlson. The facial challenge fails under Brennan, 267 Georgia 315, and the First Amendment challenge under Rodriguez fails. Our Georgia Supreme Court is dealt with that issue accordingly in the case just cited. Mr. Farley's also challenged a number of issues involving 16-15-4, which prosecutes conduct, not associations, the court just mentioned earlier. 16-15-4B addresses behavior. 16-15-4M, in terms of the double jeopardy argument, there is no merger. I agree with Mr. Carlson and Ms. Rosenwasser for the propositions as stated in Nally versus the state at 335 Georgia Appeals 539, Loophole versus the state 300 Georgia at 233, and Anthony versus the state at 303 Georgia 399. In terms of the constitutional challenge of 418, the issue of uncharged misconduct, there is a built-in mechanism, as I talked with Mr. Farley, counsel, Mr. Menendez, about the issue of it requires the application of the 403 balancing test, and that also is found and is written by our appellate court in State versus McKinney. The Lexus site 202 Lexus 545 has been provided by Ms. Rosenwasser already. So the court is of the opinion and agrees that the issue is not nexus in his classification. So Farley's motion in those regards fails. And in terms of finally his constitutional classification of 418, the preamble, as our legislature has indicated before enacting 418, and that's 24-4-418, is the reason was that our state was in a state of crisis in terms of criminality. So 16-15-4 and 24-4-418, as I mentioned earlier, Mr. Menendez, that we certainly have 3 levels of constitutional review and review to challenge the constitutionality of statutes: highest strict scrutiny, intermediate scrutiny, and then rational basis. And since our legislature has indicated that the purpose of the statute is one of the specialized statutes in terms of public safety, public safety is a relatively low bar for a governing body to meet, and most statutes that are enacted for that particular purpose are found to meet that standard. And for those reasons, the court is going to deny your motion in terms of constitutional classification. So that, I think I've ruled on everything at this point in time. Mr. Carlson and Ms. Rosenwasser, if you would prepare a suitable order as quickly as possible to permit us to go ahead and let us enter that in the record, that would be greatly appreciative. Okay, all right. Mr. Johnson, you stood up for something?
Yes, Your Honor, as you were aware, we had joined in on Mr. Menendez's motion with regards to different counts in the indictment. I did not hear anything from the state as it relates to that. I know that the court just issued a ruling as it relates to the counts that Mr. Menendez brought up, but I did not hear anything as it relates to the matters that I brought up.
Which counts are you talking about for your?
435.
Oh, you want to address that, Madam or sir?
Your Honor, I can certainly try to address it right now. I haven't done it. This was not written, so I don't have a written response for it. Your Honor, to the extent he's challenged, I think this is Mr. Effinger, is challenging only 34 and 35. Your Honor, I could just have a few moments to review.
I tell you what, I'm going to reset. Did you file a written motion, sir?
Not on that, I joined in to Mr. Menendez.
Say again?
No, Your Honor, I joined in to Mr. Menendez's motion.
It's a new count, so I didn't know if it was.
Yeah, it's not the same issue, because that count doesn't apply to you. It only applies to him. So you probably need to go ahead and reduce it to writing. But I'll go ahead and let her go ahead and do that. No, I won't take it up now, but, because I'd like to go ahead and rule on. There are a lot of things I still have yet to rule on, so the way I can treat it. Ma'am, I'll give you about 10 minutes, and then we can go ahead and finish that up, if you don't mind. I need to... All right, we're going to go ahead and do that. Councils, since I can't talk with all of you, can you all send a representative up here to the bench, please? And then the rest of you can pick one or two of you, and then I can go ahead and I'll talk with you.
Number 2 will be that we'll have Mr. Hall. He'll be here tomorrow morning at 9 o'clock. And to that extent, ladies and gentlemen, I have talked with our sheriff's department, and they will endeavor to have everyone here ready to go for 9 o'clock. So if you all could be here correspondingly for that time, so I can, it's a fairly important witness for you all to be able to examine. So please be here before 9 o'clock so we can actually get started at 9 o'clock. So this is one morning that you really do need to be here timely. So that's the second thing that we'll kind of consider. So third will be the jury questionnaire, and that should round out Thursday, the day before Christmas Eve. So, all right. So that's what we're going to handle tomorrow. Anything else, Madam?
We can do the 2 other witnesses tomorrow. Do you want them tomorrow, or you don't want them tomorrow?
We'll put those on call. So let's just see how far we get. And if it looks like that we will be able to take those, so you can leave, just as long as Mr. Tanner and Mr. Kilgore are, within about maybe 20 minutes, 30 minutes, maybe 30 minutes, we'll call them just in case. So. And remember, folks, for the jury questionnaire, Mr. Kearns has sent that to you all. So I'll do it by the following methodology, as I mentioned earlier. If there's no objection, we'll just, and these are the questions that we're going to ask the prospective jurors to speed up the process of selection. Of course, I will have a generalized introduction. And I will also have I will probably record the indictment so that it can be played three separate times, the introductory announcements as well as the indictment, and then they can fill out their questionnaire, and I can then take hardships at that point in time thereafter. So the goal is, again, 200 per day, and we'll go ahead and that should allow us sufficient time to start to be prepared for the 9th to go ahead and get started with examination, individual examination and panels. So, and I, of course, will provide you wide latitude as the law requires to ask, any questions of any individual juror. So even if you didn't think about them during the court's general questions, okay, I'll still allow you to ask those questions as part of that. So not to worry if you think this is going to be your one and only chance to do so. But it's more so, I got to get the questionnaire done. It may be the 95, 96% solution at this point, but given just a way to call in and summon these particular individuals, that is, we've already put that process in place. So just be prepared for that. And unless you all have any other administrative announcements from me, we'll be in recess tomorrow morning for a 9 o'clock anticipated start time, okay?
Judge, quick question. Where are we reporting for jury on the 4th, 5th, and 6th? In here?
No, it'll be in 1C. That courtroom will be configured at that point in time, depending upon how many persons are still remaining that are trial ready at that point in time. So yes, we will start. That issue is being worked right now, and it will be dependent upon what I just indicated. Anything else?
Just to confirm, because as I said, I had my calendar the 5th, but we're starting on the 4th. Is that correct? Here on the 4th at 9?
We'd originally discussed the 5th and 6th, but I think the 4th had been added at the request of the...
Yeah, the 4th, the reason being is because it's 200 per day. There's no way we're going to get 400 jurors examined in one day. So it's going to be is pushing with 200. But I fully suspect that that there will be a number of people that wish to be examined for hardship, and that'll be our challenge each day. So
I'm just getting my confidence ready, and I want to make sure
Yeah, every trial judge in the metro area is very anxious for all of you and your presence in other locations, so. Okay, all right. Anybody else? Any other administrative concerns? Okay, then we're in recess until tomorrow morning. I'll see everybody then.
What are we doing Monday?